Welcome to the Board of Behavioral Sciences. We are meeting this morning. It is 8:33 on November 21st, 2019. We are meeting here at the Board of Pharmacy hearing room located at 2720 Gateway Oaks Drive, number 105, Sacramento, California, 95833. Typically at this point, we'll call for a quorum. I would normally have the board introduce themselves, but we're going to wait because the judge will have us do that on record. So let's go ahead and get the quorum.
Good morning. Christina Wong.
Here?
Crystal Anthony.
Here.
Dr. Leah Brew.
Here.
Jonathan Maddox.
Here.
Betty Conley.
Here.
Max Disposti.
Here.
Deborah Brown.
Here.
We have a quorum.
Thank you. And before we move to our hearing cases, is there public comment for items not on the agenda? Okay, seeing none, are there any suggestions for future items? No. Then I'm going to turn this over to Judge Gavin, who will be presiding today, and we will introduce the board members after we go on record.
All right, thank you. Good morning. We're not on record yet. For all the petitioners, I just want to go over a couple of the ground rules so you kind of know what to expect today. For each individual petition, once your matter is called, I'll have you come and take the seat at the table next to Ms. Crawford. I'll call the case, we'll go on record. I'm going to have each board member identify themselves and establish a quorum for each individual record because that way each is self-contained. Once you're seated and we call the quorum, and I introduce myself, I'll invite the parties to introduce themselves, starting with Ms. Crawford. You'll introduce yourself. Ms. Crawford will then give just a brief overview of what your petition is to orient the board. She'll introduce the petition packet that you have. I'll mark that, ask you if you have any objection, and then we'll admit that into evidence, and then we'll turn it over to you. You'll be sworn in to tell the truth. You will then have the opportunity to present evidence on your own behalf, either in the form of your own testimony or testimony of others, or the presentation of any additional documents. Keep in mind that the board has your petition packet already. They've already read it, and so you don't need to go into great detail about things that are already in there. Keep also in mind that the board is particularly interested in rehabilitation as opposed to litigating the underlying facts that led to the discipline in the first place. That's already been litigated. It's not really up for debate here. The board's more interested in knowing, most of the petitions are for early termination of probation, with I think one exception. But the board's more interested in knowing what rehabilitation has occurred, justifying that request. Once you've presented your case, the board and Ms. Crawford will have the opportunity to question you. Please answer those questions honestly and straightforwardly, as we will know if you are not. And at the conclusion of that, we'll close each individual hearing, and then there'll be a closed session at the end of all the hearings. So you're free to stay. If you're one of the earlier ones, you're free to go. It's up to you. That's sort of the anatomy of the hearing. Any questions about any of that? Good. Second thing, with regard to a court reporter, the court reporter is here typing everything anyone says. That is to create a record of what happened here today. That means four things for us. Number one, it means we need to speak loudly enough, slowly enough, and one at a time enough that he can clearly hear what was said and type it down accurately. He's very talented, but he cannot type in stereo. So it may be that I say, hold on, and direct traffic in that regard. I'm not trying to be rude. I'm just trying to protect the record. Number two, it means that we need to communicate with words as opposed to gestures or non-word sounds. Nodding your head communicates information to us, but it doesn't get captured on the record. Similarly, and will communicate information, but the record will look like UH-UH, and we won't be able to tell what was said. So if that happens, I may say, is that a yes or is that a no? I'm not trying to put words in your mouth. I'm just trying to protect the record. Third, it means that the thing we have to keep in mind is if the court reporter for some reason doesn't hear something you said, he may ask you to repeat it. When he does that, he is not questioning you as a witness, and he's not asking you to provide any testimony you didn't already provide. So if you were to say, I saw Dr. So-and-so, and he said, pardon me, what was that? You wouldn't say, he's my orthopedist from Roseville. You would just repeat the exact name you just said. He wants you to use the same word or phrase, but louder and slower. And then fourth, at the conclusion of your hearing, the court reporter will have a document, it's a one-page document, detailing and describing how you can order a copy of the transcript. So please don't leave without getting a copy of that. As soon as you get that, you're free to go. Any questions about the court reporter? Okay, good. Any questions from the board about any of the procedures before we go on the record? All right. You ready? All right, we are on the record in the petition for reinstatement or modification of penalty of Matthew Woodbury. This is case number 2019-100902. My name is Sean Gavin. I'm the administrative law judge assigned to hear this case. First, I'd like to invite the board members to identify themselves, starting with farthest on my right.
Christina Wong, LCSW member.
Crystal Anthony, LCSW member.
Leah Brew, LPCC member.
Jonathan Maddox, MFT member.
Betty Conley, LEP member.
Max Disposti, public member.
Deborah Brown, public member.
All right, thank you. And previously, we've established that these board members constitute a quorum. Mr. Woodbury, are you here? Can you take the seat next to Ms. Crawford, please? All right, I explained a little bit about the procedures ahead of time, but now so the record is clear, let me say, Mr. Woodbury, after I invite the parties to identify themselves, I will then ask Ms. Crawford to present the petition packet to the board. When she does so, we'll then mark the packet. I'll ask if you have any objections.
Sorry about that. I need to adjust the microphone more into your way. Sorry about that.
Thank you. I'll ask you if you have any objections to any of those documents. If not, we'll admit them into the record. She will provide a brief summary for the board to orient them. Once she does that, you'll have the opportunity to testify. I'll swear you in, and you can testify or present documents on your own behalf. At the conclusion of that, the board will have the opportunity to question you. And at the conclusion of that, the case will be over and you'll be free to leave. Any questions about any of the procedures? All right, thank you. Can I take appearances of the parties starting with counsel?
Anahita Crawford, Deputy Attorney General, appearing on behalf of the Attorney General's Office pursuant to Government Code Section 11522.
All right, thank you. Mr. Woodbury, just say who you are.
Matthew Woodbury.
All right, and make sure your microphone is on. If you don't mind, you'll have to press the button there.
Green is on.
Green is on.
Matthew Woodbury.
Thank you. And the record should reflect that you are appearing today without the assistance of counsel. Is that correct?
Correct.
All right, thank you. Ms. Crawford, would you like to present the petition packet?
Yes, Your Honor.
Thank you.
I've also provided a packet to the petitioner. Exhibit 1 of the packet is the notice of hearing for today's hearing date, and I would like that marked and introduced into evidence at this time.
Mr. Woodbury, any objection to Exhibit 1 being considered as evidence in this case?
No.
All right, Exhibit 1 will be admitted.
Exhibit 2 is the license history certification for the petitioner.
Mr. Woodbury, any objection to Exhibit 2 being considered as evidence in this case?
No.
Exhibit 2 will be admitted.
Exhibit 3 is the petitioner's petition for termination of probation, along with the attachments in support.
Mr. Woodbury, any objection to Exhibit 3 being admitted into evidence in this case?
No.
Exhibit 3 will be admitted.
Exhibit 4 is the in-house modification of petitioner's probation conditions dated June 27th, 2019.
Mr. Woodbury, any objection to Exhibit 4 being considered as evidence in this case?
No.
Exhibit 4 will be admitted.
Exhibit 5 is the decision after petition and after rejection and order effective June 29, 2018.
Mr. Woodbury, any objection to Exhibit 5 being considered as evidence in this case?
No.
Exhibit 5 will be admitted.
Exhibit 6 is the decision after rejection and disciplinary order, the amended accusation, and the statement of issues.
Mr. Woodbury, any objection to Exhibit 6 being considered as evidence in this case?
No.
Exhibit 6 will be admitted without objection.
Exhibit 7, we are requesting to be filed under a protective order, along with Exhibit 8. I have provided Your Honor with an order, should that be granted. Exhibit 7 is the counseling and therapy quarterly reports.
Mr. Woodbury, do you have any objection to Exhibit 7 being admitted pursuant to the protective order identified by Ms. Crawford?
No.
I reviewed Exhibit 7, and I find good cause to sign the protective order for Exhibit 7. So Exhibit 7 will be admitted pursuant to the protective order.
And Exhibit 8 is the psychological evaluation of petitioner.
Mr. Woodbury, any objection to Exhibit 8 being admitted subject to the protective order identified by Ms. Crawford?
No.
I reviewed Exhibit 8 and find good cause to sign the protective order regarding Exhibit 8, and it will be admitted pursuant to that protective order. Anything else, Ms. Crawford?
Not evidentiary, Your Honor. I can provide a background.
Please do.
The board issued the petitioner a licensed clinical social worker's license on June 5th of 2000, and that'll expire on July 31st of 2021. An accusation was filed on October 6th of 2015, and the board adopted a decision after rejection on October 26th of 2016, which placed the petitioner on probation for 4 years. The accusation alleged that in 2014, the petitioner was convicted of a DUI with a blood alcohol level of 0.23. Pursuant to the decision after rejection, the petitioner's license was placed on stayed revocation with 4 years of probation. While on probation, the petitioner was to undergo a psychological evaluation, psychotherapy, a dependency support program, abstain from substances and submit to drug testing, and attend education, as well as provide cost recovery. On June 29th of 2018, the board partially granted petitioner's modification petition and reduced his psychotherapy to twice per month and eliminated drug testing and dependency support program requirements. And on June 27th of 2019, the board staff reduced petitioner's psychotherapy to 1 time per month. Petitioner is compliant in all aspects of his probation. Because the burden is on petitioner, I have no further statements, but would reserve the right to question the petitioner.
All right, thank you. Ms. Crawford, what is your plan with regard to service of the protective order? Do you have additional copies for parties? Do you have a plan to make copies for everyone?
I don't, Your Honor, and I don't know that there are copy facilities nearby, so my intent was, once the order is granted, that perhaps OAH can serve those on the parties, because otherwise you'd have to sign several copies.
I don't mind signing several copies. Do you have a proof of service as well?
No.
Okay, all right. Without additional copies for everyone without a proof of service, I don't see that I have a choice other than to take it back and have OAH serve it. But for the future, you should bring enough copies so that the OAH doesn't have to.
So you'd prefer just to sign multiple copies and provide one to the petitioner at the time?
Yeah, it's better
Okay.
to provide them at the time, because as soon as the documents are now received, technically they're part of the public record, so the protective order doesn't take effect until it's served on everyone.
Okay,
So just to eliminate the gap
absolutely.
in time, yeah. But that's how we'll handle it. OAH will serve it.
Okay.
All right. Mr. Woodbury, can I have you stand and raise your right hand?
Yes.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you could go ahead and have a seat. Just state and spell your name for the record, please.
Matthew Woodbury, Mathehew, Woodbury.
All right, thank you. And this is your time to present your evidence. As I said at the outset, the board has had the opportunity to review the petition, so you don't need to go in depth about anything that's contained within that. However, the board is particularly interested in rehabilitation that you believe supports your petition. So with that, you may testify.
Okay, I wrote a fairly brief opening statement, and I think that it pretty much stays within those limits. So I want to thank you for your time and for the opportunity to be here today. I appeared before you about 1.5 years ago, and I really want to thank you for listening to me at that time and trusting me enough to lift the two most restrictive conditions of my probation. That would be the biological fluid testing and the 12-step attendance. This has allowed me to direct my time, resources, and energies towards positive activities better suited to my well-being and personal growth. Today, I'm healthier and happier than I've ever been. I'm here to ask you to consider early termination of my probation. I completed my 3rd year of probation last month, and while the hard part is over, I'd really like to find closure and end this challenging chapter of my life. The only remaining terms I have are my monthly sessions with my therapist and the annual probation cost fees. My therapist and I both feel that we've done some important work, but are at an appropriate place to discuss termination. I am grateful for my connection with her and happy to know she'll be available to me should I need to do another piece of work down the road. Next July 4th will be 6 years since my DUI. As I've related to the board before, I began taking steps to mitigate the problems in my life shortly after that day. During this time, I repaired a broken relationship with my partner of 15 years with the help of couples therapy. I discovered yoga and mindfulness meditation. I returned to a neglected interest in fitness and nutrition. I lost 30 pounds of excess weight and rediscovered balance in my life. I also dusted off my oil colors and brushes and reconnected with a long-held passion for painting. These are just a few of the positive life changes I've made over these years and continue to enjoy to this day. It's my hope that you'll consider these 2 years prior to my probation as relevant to this process. I understand the single most important duty of the board is the protection of the public. I work with a vulnerable population whose lives can literally depend on the competence of practitioners, so I fully appreciate the importance of your task at hand. I hope, in addition to the personal steps that I've taken to better myself, that the board will consider my 19 years in practice as an LCSW and my 23 years of continued employment with Kaiser Permanente. I know that longevity doesn't necessarily guarantee quality, but I can sincerely report to you that through the years I have practiced with care and compassion. I've had nothing but exemplary annual performance reviews. I love my work, and I'm truly grateful to the board for supporting me in my ability to continue my work. through this process. While I find myself in a much better place in life than I did in 2014, I live daily with the memory of the terrible mistake that I made on that 4th of July. I have no doubt that that experience will continue to impact me and inform me for the rest of my life. I will always remember the gravity of my behavior and choices made that day. I will always be grateful for not having caused physical harm to anybody in that dangerous situation. Thank you for your consideration of my petition.
All right, thank you. Do you have any additional documents that have not already been submitted as part of your petition that you'd like to introduce today?
I just brought 14 copies of my opening statement. I provided them.
It's up to you if you'd like to submit those as an exhibit or not.
If it's customary, sure. I told Craig I chopped down 14 trees, so I might as well share them with you.
All right. And where are they now?
It's under the trees.
Oh, I see. All right. Thank you. All right, your personal statement, which is one page, will be marked as Exhibit A. Ms. Crawford, any objection to the admission of Exhibit A as evidence in this case? No. Exhibit A will be admitted without objection. All right, any additional documents or testimony you'd like to offer, Mr. Woodbury?
No, thanks.
With that, then, I will open it up to the board to see if the board has any questions.
Okay.
Oh, we were waiting for, we touched usually.
Does the board,
It's okay, sorry, we got by surprise.
does,
Used to, being questioned by, the DAC first.
sure, it's fine with me if that's how you want to do it. In my experience, the board usually wants to get right to their questions.
Oh, wow.
And so, but that's okay, you can do it that way.
You want me to?
No, you go. I'll go first, fine. Christina Wong, LCSW member.
You revolutionized everything.
Yeah, that's right. So we've seen you last year, right?
Year and a
s-
half.
A year and a half ago. So, tell me about, the change that, between now and a year and a half ago.
Not, excuse me, not a whole lot of change between now and a year and a half ago because I was doing really well a year and a half ago, but I have maintained a really good balance in my life. I continue to have no interest in drinking. I continue to have a very strong focus on mindfulness, meditation, and yoga, and fitness and nutrition, and almost fanatically so. So it's I really can't stress to you enough how little interest I have in putting alcohol in my system, or Diet Coke, or trans fats, or corn syrup, and all those terrible things. They just aren't a part of my life, and so it hasn't been a struggle or a temptation or character building in any way for me to avoid alcohol, because it's just not something that I have a relationship with.
So what's next? If the board grants you probation, you're able to have your closure, like you say.
Yeah.
Then what's your plan?
My plan is to continue on my path and continue my involvement in activities that I think are very fulfilling and promote stability and spirituality in my life. Thanks.
Well, I'm really good at commenting since yesterday. So I just want to make some comments. I can sense your genuineness, and I just want to acknowledge you for the work you've done, because I can see it in just your presence. I can tell you do mindfulness and yoga and stuff like that. So with that, do you feel that those are going to be things that are going to be just part of your daily life for all the years to come? I mean, is that going to be who you are forever?
It very much feels that way. I literally am up every single morning at 5 a.m. and I'm doing my yoga by 6 o'clock, and it's like brushing my teeth at this point. And when something comes up where, for whatever reason, my yoga group isn't meeting or I'm traveling, and so I'm not necessarily going to be doing my routine, I'm still up at 5 and just kind of, what do I do with this? You know, it really is habitual in a way that feels really, really great. And I can't imagine deviating from those practices. Thanks.
Hi, thanks for coming in. I recall from our last meeting, one of the thoughts that we had as a board was that therapy had been really beneficial for you, and it would be helpful to get a little more time under your belt. And you talked about some of the external behaviors in terms of maintenance and your value system about fitness, nutrition, and spirituality. I'm wondering about your personal growth work, if that's changed at all in the last 18 months or so.
My personal growth has changed in that the practices that I've learned through therapy with respect to emotion regulation and honesty and vulnerability and risk-taking in my relationship and communication in my relationship, those are things that that get stronger every day, and I think will continue to get stronger every day. But I've never felt more confident in my life in terms of having tools to access if and when terrible things happen in my life.
Have you had any challenges in the last 18 months or so?
The first one that comes to mind is a few months ago, we lost the four-legged love of my life.
I'm sorry.
That I've had for 15 years, and it was heartbreaking, and not just the loss, but the process around the loss. It was never clearly understandable when the right time to stop that battle would be. My partner and I had very different feelings about that, which created conflict, and we dealt with it in such a radically different manner than we would have 6 years ago. We actually had new verbiage like, I really feel this way, and I understand how you're feeling, but can we look at it from my perspective? You know, things that just would not have entered that dynamic years ago. It's very different, and we got through it, and ultimately we were closer because of it.
I'm sorry for your loss,
Thank you.
but I'm also warmed to hear that you were able to navigate that difference
Thank you.
better. Yeah.
Good morning.
noise when I
I know. Good morning, and thank you for coming back. I actually don't have any questions. I just want to just acknowledge the growth the growth path that you've been on. Really appreciate your increased self-care and the expanded life activities that you've been able to tap back into to really support a balance in your life. You really sounds like you're really sort of actualizing things that are really important to you, and so it's wonderful to hear that. And just the expanded toolkit that you have to navigate relationships and challenges and things of that nature.
Yeah.
So it sounds like you're really settled in your capacity to manage difficulties without alcohol. So that's fantastic to hear. So thank you for coming back.
Thank you.
And I have no questions as well, but would also like to acknowledge the work that you've done, and thank you for coming in.
Thanks so much.
On the side of the board as well, thank you so much for being here. And it's a pleasure to see you again and see the progress and sharing it with us as well. So we know it takes a lot of strength and effort. So we appreciate that. Thank you.
Thank you.
And I, too, echo the rest of the board. I have no questions, but thank you for coming today, and you look really good.
Thank you so much.
All right, thank you. Ms. Crawford, thank you for waiting. Do you have any questions of the petitioner?
Just a couple. Mr. Woodbury, you've said that you no longer have any interest in drinking.
Correct.
Prior to your DUI, what would you say your relationship with alcohol was? How would you define it?
I didn't have very much of a relationship with alcohol. I had spent most of my life not having any relationship whatsoever with alcohol. And as I told the board the last time we met, moving to San Francisco, coming out as a gay man, finding that such an integral part of the culture, I sort of pushed myself into it, even though it just was not a lifestyle that I was used to. And so kind of went through the motions socially and continued to do so, but never, nothing like I did, on that day, on that 4th of July. On that day, I weaponized it, and I drank with a purpose. Because I was in an extremist state of I just was in a self-sabotaging mode. And that was my only incident of relating to alcohol in that way, and the last.
And what was
First and last.
You said you used it for a purpose. What was that purpose on that
The
day?
purpose was to anesthetize myself in a very painful situation.
That was happening in that moment?
That was happening in that moment on that day at that barbecue. And it's terribly regretful.
And I know that you have also mentioned to some of your service providers that your partner, it is very commonplace for him to drink. It's not anything he has a problem with. Does that cause any kind of issues for you or stress in your relationship because you don't drink and your partner does?
It doesn't. It doesn't. First of all, because it's not triggering for me to see people drink or to be around people drinking. It's wonderful for me to have the self-confidence at this point in my life that I'm completely fine not drinking with them. I used to feel like that's something I needed to do to be in a social situation. At least the pretense of drinking, that's ridiculous to me now. And also, he's been incredibly sensitive and definitely made changes to his own pattern of use of alcohol over these years.
And one last question. Probation can be a challenge, as you've indicated in your letter.
It can be.
But it can also be a very strong external motivator. And it's something that could help you get up at 5 a.m. in the morning and practice your yoga and be very diligent about it. Have you accounted for, if this board terminates your probation, the absence of that potential external motivator and how it will affect your day-to-day routines?
I can tell you with complete honesty that there will be no impact at all. Whatever motivated me through this probation process to do things positive, healthy, helpful for myself, whatever instigated those activities, it is 100% internalized, and I enjoy the benefits of my lifestyle, and there's no question that any of that will change. I'm happy with how I am today, and that's not going to change.
Thank you. I don't have any other questions.
Any follow-up questions from the board members? Seeing heads shaking in the negative way. All right. Anything else that you'd like to add, Mr. Woodbury?
No, I just want to thank you all again.
All right. So in a moment, I'm going to ask if the matter is submitted. And by that, I mean, do you feel satisfied you've had the opportunity to present all evidence and make all argument on your behalf? Ms. Crawford, is the matter submitted?
Yes, Your Honor.
Mr. Woodbury, is the matter submitted?
Yes,
All right, the matter is submitted, the case is closed, and we are off the record for this matter.
thank you. Gotcha. Thank you.
So given that, that preference, that's how we'll proceed for this petition and those thereafter. Ms. Dokie, you heard, and again, we're not on the record yet, you heard the preliminary admonitions ahead of both Mr. Woodbury's petition, but as well as the comments before all the petitions. Do you have any questions about the procedure before we begin?
No.
Okay, all right. Is everyone ready to go on the record? Okay. All right. We are on the record in the matter of the petition for early termination of probation of Anne Marie Dokie. It's OAH case number 2019-100904 and agency case number L as in Lima, C as in Charlie, 2013-1858. My name is Sean Gavin. I'm the administrative law judge assigned to hear this case. Can I have the board members identify themselves, starting with farthest on my right?
Christine Wong, LCSW member.
Crystal Anthony, LCSW member.
Leah Brew, LPCC member.
Jonathan Maddox, MFT member.
Betty Conley, LEP member.
Max Disposti, public member.
Deborah Brown, public member.
All right, thank you. And we've previously established that these members constitute a quorum. As I said at the outset, Ms. Dokie, after the parties identify themselves, I'll have Ms. Crawford provide a brief summary of the background information and then present the petition packet. I'll ask if you have any objections to that, and if not, we'll mark that and admit that as evidence in the case. You will then have the opportunity to testify or present additional documents on your own behalf. After that, we will have Ms. Crawford question you, and then the board ask you questions, or at least have the opportunity to ask you questions. At the conclusion, we will submit the matter, and you'll be free to stay or go. Do you have any questions about the procedure before we begin with the evidence? All right. Ms. Crawford.
Yes, Your Honor. I have provided a packet to the applicant, and at this time, I would request to introduce that into evidence, beginning with Exhibit 1. Exhibit 1 is the notice of hearing of today's hearing date.
Ms. Dokie, you have before you there a copy of the binder of exhibits. I'd invite you to follow along, because after each one, I'll ask whether you have an objection to my consideration of that exhibit as evidence in this case. Regarding Exhibit 1, which is the notice, do you have any objection?
No.
Exhibit 1 will be admitted without objection.
Exhibit 2 is the license history certification.
Ms. Dokie, do you have any objection to Exhibit 2 being considered as evidence in this case?
No.
Exhibit 2 will be admitted.
Exhibit 3 is a petition for early termination of probation and attachments in support.
Ms. Dokie, do you have any objection to Exhibit 3 being considered as evidence in this case?
No.
Exhibit 3 will be admitted.
And Exhibit 4 is the stipulated settlement and disciplinary order along with the accusation.
Ms. Dokie, do you have any objection to Exhibit 4 being considered as evidence in this case?
No.
All right, Exhibit 4 will be admitted without objection. All right, Ms. Crawford?
Thank you, Your Honor. The petitioner was issued a licensed clinical social worker license on May 21st, 1997. The license is active and will expire on October 31st, 2020. The petitioner was required to undergo a law and ethics course, cost recovery, and standard terms and conditions of probation when she was placed on probation for 4 years on June 14th, 2017, pursuant to an accusation. That accusation alleged that in 2013, the board received a complaint from a parent litigant in a family law matter to which petitioner was assigned as a court-appointed custody evaluator. The parent litigator filed that complaint indicating that the petitioner was exhibiting unprofessional behaviors in that the petitioner was contacting unauthorized individuals while collecting data for the custody evaluator's report, and improperly accusing the parent litigant of having a psychiatric diagnosis. Petitioner's ultimate custody evaluation report was not favorable to that parent litigant. The parent sought to have petitioner removed from the case and have her report stricken, and the family court refused. The parent litigant then appealed by way of a writ, and the writ petition was granted. The court that reviewed the writ determined that the evaluation reports should have been stricken and that petitioner should have been removed and disqualified as a child custody evaluator. And that court ordered the family court to issue orders in that regard. I have no other statements, but would reserve the right to question the petitioner.
All right, thank you, Ms. Crawford. Ms. Dokie, can I have you stand and raise your right hand? Do Do you solemnly swear or affirm under the penalty of perjury that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can sit. So now is the time for you to present your evidence. As I said at the outset, the board has had the opportunity to review your petition. You don't need to go in detail about anything already contained within it. But if you'd like to provide additional testimony or present any additional documents, you may do so now.
I did bring an additional document and a number of copies of it. An additional letter of recommendation from the chief of medicine in the addiction medicine department at Kaiser, where I'm currently employed.
All right. Those will be distributed now. Thank you. This is a one-page letter dated November 17, 2019, and it'll be marked as Exhibit A. In a moment, I'll ask Ms. Crawford whether she has any objection to it, but I want to give her a chance to review it first. In the meantime, is there any testimony you'd like to offer?
Thank you for giving me the opportunity to be seen and heard today. The terms of my probation were basically three things: that I complete a number of CEUs in law and ethics, 32 units, I believe, and I have done that. And then there was cost recovery, and I have paid that. And there were quarterly reports, which I have submitted timely way. And so as the result of all terms being completed, I'm asking for early termination of my probation at this time.
All right, thank you. Any other testimony or documents you'd like to offer at this point?
No.
All right. Ms. Crawford, any objection to Exhibit A being considered as evidence in this case? No. All right, Exhibit A will be admitted without objection. And with that, Ms. Crawford, do you have any cross-examination?
I do, Your Honor. Ms. Dokie, you indicated in your petition that you no longer practice family law or perform any child custody evaluations. Can you explain why you no longer do that?
I retired from the Los Angeles Department of Family Law in 2011. I was there for 17 years. I was very well thought of. I retired because I was having to commute downtown when the 2009 financial crash had a big impact on the court. And so I had 3 small children, and I decided to retire. And I did not have an idea of what else I could do at that time. I didn't really have a plan. I just knew I needed to be closer to home, and so I did that. I now have found an alternative to family law, and I am much happier working for Kaiser in the Department of Addiction Medicine. I have no need to return to that litigious, conflict-ridden way of work. And if I made a mistake here, it was in answering the calls of attorneys who began contacting me after I retired to do this work privately, because everybody knows private evaluators are often the target of complaints and of lawsuits, and so I would never open myself back up to something like that again.
So in this particular situation that brought you to the board, The evaluation was done in 2012. You indicated you retired in 2011. That was when you were
Private.
called on privately?
Yes.
Okay. And you said that you believe that private evaluators are often the target when things go wrong. So did you disagree with the ruling that the court had made, that in fact there were mistakes that you had made, or disagreed with how you evaluated that case?
I did, and I was scheduled for a 3-day trial because I had never been heard. I knew that the attorney for the mom had gone to the trial court with an allegation of bias, but I did not know that that was appealed and that there was an appellate hearing, and so I had no due process at all. I was not on the face sheet. It was now the petitioner versus the trial court, and no one made me aware that this hearing was going on, or I would have been present and I would have corrected a lot of the material facts in error that that just pervaded that entire hearing. I did not go through with the trial because the board approached me about probation instead, and I had no desire to pull out that file that was a foot tall and reacquaint myself with any of those facts. And so I accepted the term of probation, particularly because I was also working for Kaiser and very happy and had no intention of going back. Didn't have anything to prove.
So when the accusation was filed and you were provided with that due process opportunity to explain what had happened, it's your testimony that you chose to submit yourself to the oversight of the board for this conduct, more out of convenience than because you felt there was a reason for the board's oversight.
I'm sorry, I'm not quite sure what the question.
So when the accusation was filed, that is an opportunity for you to have a due process hearing.
Yes, yes.
Okay. And you chose not to go that route
Right.
and present your side of the situation because you were offered probation by
Yes.
the board.
Yes.
And so your decision to not go through a due process hearing, but instead accept probation and the board's oversight, was more because it was a more convenient route versus that you believed the board needed to have oversight over your practice.
Exactly.
Okay. And is that why you're seeking termination today, is because you don't believe there really was any necessity for you to be on probation?
Well, not only that, but also because I have no intention of ever doing that work again. And so if anyone had any concern about my work in that field, they would not have to worry about that because I'm very happy where I am. It's a better position than I even had at the Family Law Department, and I have I'm going to retire from Kaiser.
Do you have any concern that as a child custody evaluator, you were looking at what was in the best interest of the welfare of a child? And certainly as a therapist in any field, you are still acting in the capacity of someone who conducts themselves in a manner that's in the best interest of their patient.
Mm-hmm.
Do you see that those two things are parallel?
Yes.
And so it doesn't necessarily require that you be in family law to have that obligation.
Right.
Can you see why the board would be concerned, regardless of the area that you're practicing in, if a court, upon review of your practices in family court, determined that in some way you took action that was not in the best interest of a client?
Yes, I can see how they would.
And how would you reassure this board that no matter the area of practice, that something of concern, such as not taking the best interests of a client into account, or in some way becoming biased, is not going to be something that they need to be concerned about?
Well, first and foremost, I've provided 2 letters of recommendation from a colleague and from the chief of medicine at Kaiser, and they both, I think, attest to my work ethic, my ethics, and so I would encourage the board to look at those and, recognize that family law, the best interest was of the child, not of the parent who ultimately wanted to litigate this further. And so I submit that I was looking at the best interests of the child in that case, as I am now with my patients that I see all day long.
The individuals that provided the letters of recommendation, were they aware of this appellate case and the decision of the court regarding your evaluation responsibilities?
Yes, they had to have been.
Okay. Thank you. I have no other questions.
All right, thank you. With that, let me turn it over to the board, starting with Ms. Wong, to see whether the board has any questions.
Good morning.
Good morning.
So, I'm reading, back some of the documents that, that the board submitted, in regarding your settlement and stuff like that. So it looks like you did go through a pretty lengthy process, have an attorney, to help you, respond, to some of the questions.
Not until after the appellate court hearing. I couldn't even get an attorney during that time because my name was not on the face sheet and my malpractice insurance did not see me as being harmed. And so I had no representation, which I would have gone in on my own had I known that it was happening. Thus, again, another reason why mental health professionals need their own firm of attorneys to do this work, because I didn't know that was what was going on.
Okay, so let me just clarify. So you were, after you retired, you enter into being the child custody evaluator in 2011?
Yes, it
And
was
so
at the
that
end
was-
of 2011 that I retired, so 2012.
So how long have you served as the private custody evaluator?
How long had I? No, I'm not doing any of that work since 2014.
So you were, doing that work for about 3 years?
5 years, it's 2019 now.
No, what I meant is how long did you do that
Privately or for the family law department?
privately? Because
2
that
years.
was 2 years. Okay. So I'm hearing you saying that it is a very difficult situation. So now in the hindsight, because the accusation is also pretty accurate. I mean, pretty not accurate. It's not about it is about diagnosis. About that acquiring information. For from unauthorized people and stuff. And so now in the hindsight, what could you have done better, or way to protect yourself so that you don't make the same mistake again, or if really it's a mistake in your eyes.
If I had done those things, it would be a mistake in my eyes. But the contact of the person who I shouldn't have contacted, there were 2 evaluations. The first one, the person that I contacted was on the list of approved people to contact. It was an inadvertent error that during the second evaluation, I contacted that person again for an update. And the mother had rescinded the release of information, and it was just as soon as I called the person, I realized it, and I hung up. I ended the call. There were a lot of things in that appellate decision that had I been there and been able to respond, I think maybe the decision would have been different. I have always been confused as to how that hearing came out the way that it did, because I believe that they were arguing case law, and the marriage of atoms, you know, the evaluator was egregious in the things that were done. You know, the ex parte contact, I hit reply instead of reply all. I did everything in that evaluation the way I was trained through family law department, and I have done over 500 evaluations. I submitted with my packet of information when I did have an attorney, at least 20 judicial feedback forms, pretty much extolling, you know, my virtues as an evaluator. With over 500 evaluations and 17 years and all of that judicial feedback, the idea that I would change how I do things in this one case doesn't make a lot of sense, I don't think, to anybody. And unfortunately, I wasn't there to point that out, and I wasn't there to say, no, I actually submitted, you know, an additional thing in concert with the way I was trained. I wasn't given those, you know, get that opportunity. So I don't think that there's any chance that those circumstances will repeat themselves. And I work in a completely different line of work where people are coming in at the most vulnerable times of their life in completely broken state. And, you know, my job is to help, is to partner with them to try and put that back together again, starting with their recovery and achieving and maintaining sobriety. I have the utmost respect for that struggle and for all of the issues that attach. And yeah, I mean, that just comes from doing this work daily. I hope I answered your question.
Yeah, absolutely. So the follow-up question is that, I'm sure that, you have your understanding about what happened, and, and you really make the attempts to kind of clean up the mess and, have your voice heard. And yet you also agree on the stipulation, from the board. Why would you do that?
Because this is a messy case. It was a litigious situation, and I was happy where I was. I don't need to prove anything to anyone. I know what I know, and I'm employed. I'm raising my kids. I would have had to use spring break to do that hearing, and I had plans with them. It just wasn't, it didn't seem like it was a good return on investment to say, yay, I won, when, and what I would have to go through to get all that done.
Thank you very much.
I don't have any questions.
Thank you for coming. When you applied for your position at Kaiser, did someone there in that hiring process get to know the full story?
I didn't know the full story at that time.
Oh, okay.
Or because if I had and hadn't, disclosed that, I would not be working for them right now.
Okay.
I applied for that job in June, July of 2014, and I got the job in September, and then all of this, the trial court had made its determination sometime in April or May. The appellate court didn't release the hearing or didn't make its determination about that hearing until the day before Thanksgiving 2014, so that was November. And the way I found out was the media was calling me and asking me what my opinion was on this finding that came down. So that's how I found out.
Ooh, I'm sorry to hear that.
Yeah, it was pretty rugged.
Did you ever get a chance to at least consult with someone about your frustration with this case, or talk in your own therapy about it?
Well, what I did was, with the help of my husband and with the help of the president of the Family Law Department in San Fernando Valley, she gave me a pro bono referral, somebody who worked with me out of the goodness of their heart because I could not get anything from my malpractice insurance. And we put together a response in, God, 10 days. And it was a night and day. And my husband, like picked me up off the battlefield, and he researched and he helped me, and he did everything. He even cooked Thanksgiving dinner that year. And we submitted the response, and then the appellate court, knowing full well I was advised that the appellate court very rarely changes a decision, but they did take my name off the case so that any further reference, it would be the evaluator and not me. So they did do that.
Okay.
And I've had a lot of therapy, not pursuant to this per se, but just recently I had a car accident in April that was so traumatic. It really shook loose a bunch of things that I had not dealt with from early childhood, and I went into a PHP program for 3 months because I was really pretty symptomatic, and have been really just better than ever after that.
So you know how to take care of yourself.
Yeah.
Okay. Yeah. I just, as a context, I asked that question because I'm like, well, if Kaiser knew and they hired you, then, or does somebody know about the full story and support unit? Because obviously we can sometimes be blind to ourselves in some areas, and I was kind of looking around for a way to get more information other than the letters, which they're also good, to find that out. But I feel like even this story with, not the story, but the event of your accident and going into therapy and knowing that you have to work on things from time to time helps give me more comfort, I guess. Yeah.
I sat down with both my direct manager and with Dr. Rad Pavar, who's the chief, and I explained how this happened step by step by step, because it did matter to me that they knew that I wasn't that person that is described in that hearing information. And I explained to them how, because the 2 evaluation reports that I had done were never submitted into evidence, there was never a hearing on them, so they did not travel with the case to the appellate court. And so what ended up happening was this attorney got this hearing based on some emails that he kind of chopped up and didn't even present in their entirety, because if he had, there would have been clear evidence of me saying, I cannot speak to you any further. I am no longer the evaluator until a new court order is issued, if and when it is issued. And none of that was evident. So it was a dirty deed. And I wanted the people to know who were judging me on my performance with their patients, that this is how that happened.
Okay. Yeah, that helps to know that they know that, the story, and they still have confidence in you.
Yeah.
Thank you so much.
Sure.
Good morning. Thank you for
morning.
coming.
Thank you.
So I guess my first question is, so there are a lot of points of concern that you agreed to when you accepted to be on probation with the board, with BBS. And so I'm wondering, is it your testimony today that you don't agree that you did those things, but it was just more expedient to sort of have us oversee your probation versus like the DAG had asked, rather than going through a legal process? Is that your testimony today?
Yes.
So it would be fair to say, not to recount and rehash everything, that the accusation of false advertisement is not true?
Oh, I am so sorry. That is the one thing of all of that stuff that is true. I was practicing under the name Ann Convertino for 17 years, all through the court. I got married and just never thought to change my name, and it became a brand. The Family Law Department is a small group of evaluators and mediators, and everybody knew me that way. And I worked for the court for another 9 to 12 years under that name, and just never thought. As soon as it was brought to my attention, I was, oh my gosh, and I changed everything.
Sure, that's understandable.
Immediately.
No, that's
So
understandable.
that's the one thing that I did do wrong, aside from taking that case.
No, thank you for the clarification, because brand is important. Tina Turner did the same thing. When she left Ike, she said, I want my name.
Yeah.
I understand that. So
I'm
the
a
other,
big company.
so the other, failure to maintain confidentiality, intentionally or recklessly causing harm.
The confidentiality
I'm not
piece
done.
is what
I'm not done.
I'm sorry.
The unprofessional conduct, gross negligence, and the it's a few pages, and the unprofessional conduct, incompetence. Those are all inaccurate sort of characterizations that you did agree to just because it was more convenient for you?
Yes, I did. And if you do look at the file, you will see the 20 judicial feedback forms from sitting Superior Court judges that I think attest to the quality of my work. There were also, performance evaluations from the Family Law Department that attest to the quality of my work. I can't help what they made of this case, but I know what I know, and
Sure.
I don't believe that I was any of those things except for practicing under the wrong name.
So those evaluations that you just referenced, was that your work in general as a CCE evaluator, or were they specific to this case? 'Cause those are two very different things.
I don't think that they are, actually. I said, as I said before, I was trained and I had procedures, and I followed those in the course of 500 evaluations before this case. I didn't change anything.
So I would disagree. I think they are very different. I think it's very different for someone to look at your scope of work over a period of time and say, based on my evaluation of your work over time, this is my sort of, this is my evaluation of that, versus someone looking at doing an audit of a particular evaluation and saying, based on the audit of this evaluation, I'm making the same appraisal. So I would see them as being very different. So I would restate my question. Was that evaluation that you just described about the broad scope of your work over time, or was it specific to this evaluation?
I think I followed every procedure and did everything well in these two evaluations that are at issue here.
Okay. So based on my question and based on what you said, it sounds like you're not saying, you're saying in your opinion, you followed everything, but I'm saying the scope of what you just described in terms of evaluation of your work was not specific to this evaluation, is what I'm asking.
Yes.
Okay. So just looking at the accusations, are any of them, it sounds like you don't believe, in your opinion, any of them are true, not sort of gathering information from sources where you weren't supposed to, or?
Well, I did say that I inadvertently called somebody who was on the no-call list in the second evaluation. It was inadvertent, and it was a mistake, and nothing was ever included from that person. But that person let the mom know that she had been contacted, and there was a very concerted effort to, if you can't argue on the content, you go after the character of the person who created the work product. And I think that strategy is front and center all over the place these days. I was the victim of it, I believe.
Okay. There was also accusations that you had lost your objectivity during the course of this, especially as it relates to, I guess, the parent's ex-spouse?
Yeah, that was ridiculous.
So you would say that those are inaccuracies also?
Yes, I would. I think that is a, what's the word for an attorney who would make a statement like that? I'm happily married for 20 years. I have 3 children. I am not having cozy conversations with anybody. Again, how can we make it look a certain way when it seriously was not that way at all?
I'd just like to invite each speaker to keep their volume up so all other panel members can hear.
Sure, thank you. Okay, so, thank you. So, I'm a therapist. I know that we are all human and we have the ability to sort of do our work from blind places within us. And so help the board understand sort of how you protect yourself from counter-transference reactions in your work. Because I know you have described the work that you did then and now as very different, but as a therapist, I would see them as very similar. We have very intimate relationships with our clients. We have access to protected health information. We have to sort of follow legal requirements to share that with other people. So I'm wondering, how do you protect yourself now from your own humanity when you're working with other people?
Well, I think it's the humanity that really shines through and helps me to connect with patients. We have a case conference with, peers, during which, if I were to feel as if I was not working effectively with someone, I could discuss that, or if they, through my presentation, had those concerns, they could raise them. So I've always believed in, peer-reviewed type examinations of your work, because it is very behind closed doors, and how would anybody know otherwise?
Thank you. I don't have any further questions.
Good morning.
Morning.
I don't want to repeat what other people have asked. I'm still struggling with a little bit of it. And I think you've answered to some extent. I'm still puzzled. As strong as your case appears to be, and as well as you have articulated your defense or rebuttal of the situation, I'm still puzzled that you did agree to the step 2 years ago. I have to admit that if you'd have come forth with what you're saying today, with the evidence that you had, and yet I still am just really puzzled that you went that way.
It is unusual. It was an unusual decision. I mean, most people would go forward, I think. I think another thing, when I think about it, my attorney told me that even if I prevailed in the hearing, the board could disallow the decision. That really deterred me, because, why go through all of this and then potentially not, end up in this position anyway. So that was a piece. But really, I was just done with the fighting, with the allegations, with the cross-examination, with with all of it. And it's why I, interviewed with Kaiser. I just didn't want any part of it anymore. And it wasn't, again, I tend to have some pretty good, I didn't need to prove it. And I know that that's unusual too. I don't know if there's even, ramifications for that, but that's how I felt at the time, and that's why I decided to do what I did.
So here we are 2 years later,
Mm-hmm.
and you're asking to be off of probation.
Right.
What's the reasoning for that then? If it was just like, let's just get it over with and just do why now does it?
Because I've fulfilled all the terms of the probation, and the terms really were just complete the CEUs, file the quarterly reports, and make the cost recovery payment when I've done all those things. At this point, my probation would be sending in a letter every 3 months, checking every box no, because I didn't have any of the standard things.
Terms, yeah.
Terms. And just, letting people know that I have not been arrested for anything, which, in 59 years, I've never been arrested for anything, and I don't see that as really a risk.
So is being on probation, is continuing on probation, is that impacting your relationship at work or with anything that you do? Is it having any negative impact whatsoever?
It has a negative impact on my being tied to this very awful period of time. You know, I mean, getting a call, Miss Convertino, do you have any comment on the, you know, it was awful. And I may look kind of put together right now, but I really was like crucified publicly. My name, Tina Turner got her name. My name is worth nothing now, because there are still places, my maiden name anyway, there are still places on the internet that have evaluator thrown off case, and you know, just all of the buzzwords that this attorney managed to get into the record. So now it is the record, and I would like to be done. I would like to continue my life and not have to be continually sending in this paper, and if I forget, you know, the medical board from Kaiser is, where's the paper? You know, I don't see any reason why not.
Okay, thank you. Thank you for coming in.
Thank you.
Thank you. Good morning.
Good morning.
Thank you for being here. I was just thinking about, I hope Tina Turner is not going to drag us into some other, who knows what kind of, if she only knows. So for me, there is a procedural issue here, because I'm trying to, it's very unusual for us to go back. First of all, we are not reopening a case. We don't have the jurisdiction to do that. It's not our intention. We stated that at the very beginning. So it's very difficult for us. I'm just going to share how I'm trying to process this, that people that come before us, we are measuring their progress and their challenges based on what we receive. You witnessed that even this morning. So it's a little bit difficult for us to come with you and dealing with something that obviously, and I respect that, so this is not a judgment, but obviously you feel compelled to share the fact that you don't identify with those accusations, but we have them. And so we can't reopen a case that's been already done. So for me as a public board member, it's a little bit difficult to measure the progress or non-progress or the activities behind it, because now I take note of what you share with us, but at the same time, like my colleague Jonathan was sharing, it's just not easy to determine in terms of safety or public safety what we should do or not. Because at the same time, it's kind of like you're asking us to believe you based on what happened or did not happen, and anything we come out to today might reflect that. So it's a little bit difficult because it put us in a situation that's unusual, just for lack of a better word. And again, I respect your choice of sharing that with us, because I'm sure it's important to you. So even in relation, I wanted to make a little note when we believe you, I believe you, that you say you're done with the practice of doing, because of the experience, you will never, ever address that. But anytime that we release probation, we don't tell people what to do or not to do. That will be awful. People are free to go with their license. They're licensed for a reason. They are free to go and practice anywhere they can. You know, if they had issues with a certain population, we can't prevent them not to work with them. It's just not what we do. So that too comes in consideration when, once again, something has happened to us. And we had to take that in consideration. I just wanted to share that with you because it's a little bit difficult for us to measure any possible progress in relation to what we just heard today. But I appreciate you being here and be honest with us in your sharing what has happened, and I'm sure the trauma associated with that. So we take note of that, and thank you. Thank you so much.
May I make a comment?
Please, yes.
I would just really appeal to every one of you that this is an unusual situation, and I did an unusual thing. Maybe that sets a precedent, because I don't know how if I should be penalized for the lack of ability to show progress beyond what I did. I paid the cost recovery, I did the CEUs, and I've sent in that quarterly report. There's nothing else I could have done. And so to continue this just continues something with no real benefit to anyone. And I don't know if I could make it any plainer that I have no intention of ever doing this work again. I work for Kaiser. I've been there 5 years. And as I said, I'm going to retire from there. I'm very well happy and well thought of, and I hope those letters convey that.
I appreciate that. Thank you. Thank you so much for sharing.
I have a couple of questions, and I'm sorry if I repeat some of the questions that have been answered, but I don't have really great hearing.
Okay,
And
no
so,
problem.
and this is my bad ear. That's my good ear, so that would be over there. Yeah. Anyway, so at any time, have you had a conversation with the board or discussed anything with the board, and I don't mean us, I mean the board, that what you're saying today, that all of that information was untrue about your case? Did you ever say that to the board or the
I
staff?
think my attorney did in the responses and the rebuttals to the accusation.
So you think your attorney responded with, she didn't do those things, but she'll take the probation anyway?
I don't actually know. She called me and said the board is offering a probation, and do I want to consider it? But I do
believe
know
we
that
have that information look at. My concern is, and I understand what you're saying at the time, it was probably the most expedient thing to do, and your frame of mind, it was the most cost efficient, I believe what you said, and time efficient to just accept and move forward. Unfortunately, a couple of things, and I too agree that I believe you're never going to go back and do family law. I think that was true, at least with the testimony today, very traumatic for you and something you might not go back to. However, your license is your license. And so we have to assume that you can do whatever that you want to do within the purview of that license. So even though you say that today, we have to take in consideration that, yes, you could go back to family law. That's up to you. So I think that's one thing that we have to consider. And the other is, I guess I do need to know whether it was communicated to the board on that you disagreed with the accusation and that you went ahead and accepted, because otherwise, to me, it's kind of, the board was duped. And we've spent a lot of time and a lot of energy and a lot of money, the taxpayers' money, to now come back and you say, I didn't do any of this stuff. But yet, you accepted the probation conditions and you moved forward with those, leading us to believe that you, in fact, were guilty of those things that needed a probation. So I think that's what is somewhat confusing, at least I'll speak only for myself, is here we are, and at the midnight hour, we're saying, well, I did it because it was convenient, but I still won't cop to it because I didn't do it. And so I was just telling you what you wanted to hear. And I just went ahead and did the probation because that's what was required of me. I'm here today to tell you I didn't do any of that. I don't believe in what was said and what was written as the stipulation, and I want out. I mean, and maybe I have missed some of the conversation, but that's what I'm hearing today. I can possibly provide some
light on that issue.
Can you turn your microphone on, please?
The stipulated settlement requires that there be some form of admission. And generally, the admission is that, yes, I agree with everything in the accusation. In this situation, what the stipulation said was, there was no full admission to the allegations. What it said was, I agree that the board could prove this if this was taken to hearing, and I agree that I am submitting myself to the board's decision to discipline my license. So the agreement is that there is an understanding that these allegations could be proven, and that that is the basis for the discipline. However, once a petition is filed, those allegations are deemed true because there is no other way for the board to determine if there's been rehabilitation. So you are certainly doing what you need to be doing and asking the right questions because those allegations are deemed true, and you cannot determine any kind of rehabilitation without them.
Okay.
I hope
And
that
so,
sheds
and so
some light.
today today we're having something that's contradicting that.
So today you are holding a hearing based on the allegations being deemed true. You are to assume that they are true. Despite how that settlement was entered into, it is accurate that the petitioner did not say, I admit everything is true. And that's allowed. Under the law, it is allowed for her to enter into a stipulation in that manner. But you are to deem the allegations true when determining
Right.
whether she has been rehabilitated.
And then we put forth the probation of what the things she has to do.
Correct.
May I interrupt for a moment? The record should reflect that Ms. Crawford's comments are, as helpful as they may be, they're more in the nature of closing argument. And so there'll be an opportunity to fill out closing argument. But for now, we need to finish with the examination of this witness. So if there are additional questions for this witness, I would invite them at this point.
I think I have enough information for me to make a decision. Thank you.
Any other questions from board members raised by any additional testimony that was given? Seeing heads shake in the negative way.
Yeah, I do.
Go ahead.
And then I just have one, and it's not, so I guess I don't know if the word is troubled, the word is confused. It just seems unique to me that all of these sort of accusations have been leveled against you about whatever procedures or protocols that you were expected to follow in that previous act. There are significant accusations against you saying that you didn't follow those. And then just a second ago, you sort of shared that you weren't quite sure what your lawyer did. And typically when lawyers work for clients, there's a conversation where the lawyer typically does what the actual client asked them to do. They don't sort of go off on their own. So could you just bring some, and I guess I'm more asking the second question, could you bring some clarity sort of about, I don't even know if I have a question.
What went on there?
Not so much what went on there, but I'm at a loss for where you are in all of this. It sounds like all of these unfortunate things have happened around you and to you, and you were like, this is terrible that this has happened to me, but I don't hear any sort of responsibility for, so is there any, I guess the question is, what responsibility can you take based on all of these things, whether it was the accusations actually leveled against you, whether it was sort of how you have worked with the board to get to where you are today? Are there some things you can take responsibility for? We would like to just hear something from you about, how this has impacted you, because I haven't heard anything yet, and so I'm just wondering.
Back in the day, I was considered to be an expert witness, so I answer the question, and I'm not particularly effusive about how I feel about things. I should never have taken that case. sometimes at the end of the day, your integrity may be the only thing you have left. And so what I am going to say may not get me off probation, but I followed the procedures that I have always used for 17 years, and I argued an alternative theory in that case, which was not even noticed in any of the proceedings that did happen to me. I think I controlled for bias. I had a case conference around this case. You know, I did the things that I was trained to do, and I did them in the way I was trained to do them. It was tremendously traumatic. And, you know, I did not go into this cynically to dupe the board. My attorney took all the judicial feedback forms and sent them in, and then called me up and said that the board was offering a probation option, and did I want to consider that? And when I talked with her about what the chances were of prevailing in the hearing, and she said that the decision could be disallowed by the board, that kind of did it for me right there. That was the last straw. But, you know, all the things I said previously about just being done with all of this litigation and all of this accusation and examination, and that's why I did it. And it is very unusual. I guess most people would try and clear their name. I don't know if that answers you. Well, can I take responsibility for something?
Thank you for your answer. Thank you.
Yeah.
I have no more questions.
Any additional questions from any board members? Yes.
So I actually am pretty aware of what happens in court proceedings and stuff like that. So I have like a lot of empathy for what happened to you. But I do have a question. So there was like so much going on, and you had like basically your world falling apart. And in those moments, I guess like for me, rehabilitation wise, did you seek therapy after? That wasn't one of your conditions, but I think something that we all like to see is when people do it on their own. But I don't know, like, is that something that you seeked? If it wasn't therapy, was there other things that you did for yourself during that time to help yourself during that stress?
Well, in addition to everything else that was going on, I started the Kaiser job like right then. And so I was, you know, in a new job. I relied heavily on my husband, as I always do. I was part of a church group and was, you know, active in it, and used a lot of the people there to sort of look to a faith for, you know, understanding what had happened here. But mostly I did what I do, which is keep going. And that's what I did until, like I said, last April, the day came when that car accident created such a terror in me that my body just started to tell me, you know, I was crying all day and startling at the drop of a pin and unable to function. And then I went into therapy, and this was a piece of it. Because I believe in injustice was done, you know, and I believed very heavily in the justice system. I worked for it for 17 years. There's no way to explain it, you know. It's just something you have to get through, and I got through it in a good way.
All right, any additional questions from any board members? Seeing no hands raised. Ms. Crawford, any additional questions?
Just a couple. This private family law matter that you took on, was that the first time that you had taken on a private family law matter?
It was one of the first, yeah.
Okay, it was towards the beginning of when you were privately retained?
Yeah.
And was it the father who had retained your services?
I believe I was contacted by the father's attorney first. Yeah. I mean, I'm not retained by either parent. They get an order from the court, and then the attorneys contact me and say, you've been asked to do this, and are you available? And I said, okay.
But in this case, it was the father's attorney that selected you to be on this case?
That I don't really know.
Okay. Who paid you?
They both did.
So both parents pay for,
A retainer,
okay, so they equally shared that?
I believe so. You know, it's a long time ago. I honestly don't remember.
How does it work generally with or when you're privately retained? How does that generally work?
One of two ways. Either an attorney can contact you and say, we have this case, and then they go to court and get you appointed as the 730 evaluator. It's a different number now, I guess. Or they just go straight to court, and in the proceeding, they determine an evaluation is needed. They look at the list of private evaluators, they pick one, and then you find out you've been appointed. So one of two ways.
Okay. And you have testified about, or given us an explanation about some of the incidents that you were accused of with regards to speaking to somebody unauthorized, and you have denied that you've done that or explained kind of what had happened. And I want to also clarify that you are denying the specifics that are in the accusation, specifically item number 13 on page 4 of the accusation. The accusation is Exhibit 4.
Item 13.
And I would refer you to AGO 40. That's a small number at the bottom right corner of the page.
Okay, 13.
Okay, so item 13 is language that's taken specifically out of the court's findings, the appellate court's findings. And it goes into page AGO 41. And it specifically talks about how 3 doctors said that you had either misquoted them or misunderstood them, that the court found that you didn't rely on important sources, such as the child's therapist or lifelong physician, or a party's therapist or lifelong physician versus these peripheral sources. And those are kind of solid things that the court based its opinion on. You do disagree that those things occurred,
The
correct?
mother in this case is a Kaiser nurse, and the child was treated at Kaiser extensively. So I had handwritten notes from each conversation with each collateral source of information that could substantiate that they said these things to me. This mother went and had a fit in front of each and every one of them, and she works with them. They're in the emergency room, they're in pediatrics. And then they did what people often do, they start to hedge and backslide.
So you believe that the 3 doctors that confirmed that they had been misquoted or misunderstood, that those 3 doctors were dishonest?
Maybe they were misunderstood, maybe they felt misunderstood, but I have handwritten notes that show they said exactly what I wrote down, and I put what I wrote down in the report, so they couldn't have been misquoted.
Okay.
Maybe they felt misunderstood.
And what about the court's reliance that you didn't seek out direct relevant sources, such as a direct therapist and a lifelong physician versus these peripheral sources that maybe fit into your evaluation better?
I did actually talk to the doctors, and I got the hospital social worker. The child's record was extensive. I mean, volumes. This kid had been being seen since he was 18 months old. And so one of the ways to consolidate the record and get to the things that you need is to ask the medical social worker, that's part of the case, to summarize for you what it is that each doctor said or what was in the record. And I did that.
That made it into your evaluation?
Absolutely.
So
And I
you-
spoke in the second, I spoke in the second evaluation directly to the doctor because she had raised these concerns after the first evaluation. And I wrote down verbatim what that doctor said. This was a difficult case with a very difficult mother. The doctor felt like she was in the middle, that she was damned if she did and damned if she didn't. And she said some things that, this mother wasn't going to like. I put them in the record and in the report, and, here we are. She didn't like it, and they found a way.
Okay.
But I did go through, collateral resources are a big part of any child custody evaluation, because you may formulate a theory of the case, or one or two theories of the case, and then the way you kind of figure out which one it might be is to look at all the different collaterals and try and figure out which ones sort of confirm or deny what your hypothesis is. And it's interesting and just so ridiculous. This mom made it into the record that I didn't do the psychological testing. And I didn't do the psychological testing in the first evaluation because the court order, it stipulated I had the option to do it. I didn't have to do it. And I gave this mother the benefit of the doubt. There was a lot of evidence against her, collateral evidence. And so when I formulated this case in the evaluation section, I really said, based on this, it looks like this. And I don't really know. So what I think should be done is that there should be a follow-up in 6 months and with these things put in place, and then evaluate how she handles that. I did not say that she was mental. I did not do any of the things that are being said here. I gave her the benefit of the doubt, and very thoroughly in the report, which nobody read, said so.
So with these accusations, kind of memorialized into writing and in court cases, the phone calls you got from media and feeling like your name was besmirched. To follow up on board member Anthony's questions, have you sought therapy specifically related to this? Because you did tell board members that there's nothing else you could have done. And you're right, there's nothing else within the probation terms you could have done. But certainly, you could have sought out therapy on your own had you wanted to.
And I did want to, and I tried multiple times. Kaiser is not an easy place to get mental health treatment from, which should be evident in the news every day of the week. My mother died 2 days before I got this whole thing in the mail. And I went to therapy, and it was not just about her death, but it was also about this. I was out for 6 weeks. And then I tried again to get therapy, and I went for a period of time, and I did talk about this extensively. We were supposed to start again after a hiatus because of the holidays and different things. And then her practice was full. She couldn't take me on. And then I just kept going. I mean, I did seek out therapy twice between 2017 and 2018, end of 2018. And this factored it heavily into it. I don't want to make it seem like it didn't, because it did. This was a horrific situation where I was publicly crucified, and all of the documentation was sent to the family court, all my peers, all the attorneys, everyone who's known me for 17 years got a copy of this.
Would you seek out therapy even if probation was terminated regarding this issue? Do you
I'm
feel
still
like-
in therapy.
Okay.
I still go and see. I went to a 3-month PHP. The place is called Trauma and Beyond, and I'm still being seen in outpatient care.
What is PHP?
Partial hospital. I was there all day, for 4 hours a day,
Okay.
because I was pretty wrecked.
Thank you.
All right, any further questions from any board members? Ms. Dokie, any additional testimony or documents you'd like to offer into evidence?
No.
Ms. Crawford, any additional questions?
No, Your Honor.
All right. I characterized earlier, Ms. Crawford, your comments as in the nature of closing argument, but then I promptly cut them off and said you would get another chance to finish your closing. So would you like to make a closing argument in addition to the comments you've previously made?
No, thank you, Your Honor.
All right.
Could I make just one last closing argument? And
Yes, you may.
last statement, and that is that I kind of thought that this hearing was to really look at the probation and my compliance with it and not to relitigate the case. I kind of went with the questions that really have sort of relitigated the case, because in some senses this has been cathartic for me in and of itself. This is the only time I've been heard by anybody. But I don't think I've done myself any good in some ways, because as Ms. Brown said, it just doesn't look like the standard wheelhouse that you guys, would be comfortable moving me off of probation. And I guess so my last comment would simply be that sometimes unusual things happen and people make the best decisions that they can under the circumstances. And I feel like I've done that, and I feel like that I do a lot of good at Kaiser, and I would like to be unencumbered from this so that I can continue that and not be dragging this piece still with me for another 2 years.
All right, thank you for that. In a moment, I'm going to ask whether the matter is submitted, and by that I mean, are you satisfied you've had the opportunity to provide all evidence and make all argument on your behalf? Ms. Crawford, is the matter submitted?
Yes, Your Honor.
Ms. Dokie, is the matter submitted?
Yes.
All right, then the matter is submitted, the case is closed, and we are off the record. Now is an appropriate time for our morning break.
Can I ask a quick?
The next hearing we're going to have is Ms. Fell's hearing.
Are we on quorum? Yeah.
Yeah, we've just closing the door. Mark, are you okay to start, or do you need more time? Before we go on the record, let me just remind each speaker that while we can likely hear people next to us, we need to try our best to speak into the microphone so everyone can hear. And as I've been reminded, so the official record has clear audio. We need to be speaking into the microphone. And this is my typical time to make a reminder for keeping the pace slow enough that the reporter can make out everything everyone says. I'm not looking at anyone in particular when I say that. It's just a general reminder. Before we go on the record, Ms. Fell, do you have any questions about the procedure?
No, Your Honor.
Okay. Is everyone ready Raise your hand if you're not ready to continue. Seeing no hands. All right. We are on the record in the matter of the petition for reinstatement or modification of penalty for early termination of probation of Stephanie Jean Fell. It is OAH case number 2019-100906 and agency case number 2002-016-002-060. My name is Sean Gavin. I'm the administrative law judge assigned to hear this case. Can I invite the board members to identify themselves, starting on the farthest to my right?
Christina Wong, LCSW member.
Crystal Anthony, LCSW member.
Leah Brew, LPCC member.
Jonathan Maddox, MFT member.
Betty Conley, LEP member.
Max Disposti, public member.
Deborah Brown, public member.
Thank you. And we've previously established that these members constitute a quorum of the board. Ms. Fell, prior to calling your hearing, we gave some preliminary ground rules for how today will go. You'll have, after I call the case and take appearances, you'll have Ms. Crawford present an overview of your case and then present the board with your petition packet. We'll mark that. I'll ask if you have any objection to those exhibits, and if not, I'll admit them into evidence. After Ms. Crawford has done that, then you'll have the opportunity to present your evidence. That'll come either in the form of your own testimony or the presentation of additional documents or other third-party witnesses. Keep in mind that the board has had the opportunity to review your petition, and the board is particularly concerned with any evidence of rehabilitation following the initial license discipline and relitigating the underlying facts of the original license discipline is not the focus of what today's hearing will be. After you've testified and presented your evidence, I'll give Ms. Crawford the chance to cross-examine you, and then any board members will have the chance to cross-examine you and ask additional questions. Do you have any questions or concerns about any of that before we begin?
No, Your Honor.
All right, thank you. Ms. Crawford.
I don't know if I introduced myself, but.
Let's take appearances.
Okay.
Good idea.
Anahita Crawford, Deputy Attorney General, appearing on behalf of the Attorney General's Office pursuant to Government Code Section 11522.
Thank you. And Ms. Fell, the record should reflect that you are here today without the assistance of counsel. Is that correct?
Yes, Your Honor.
All right, thank you. After identifying yourself, thank you, Ms. Crawford. You may begin.
Your Honor, I do have a petition packet that I did provide a copy to the petitioner, and I'm providing one to the court as well, or to the board, I'm sorry. And they contain the exhibits that would like marked and introduced into evidence. The first exhibit is the notice of hearing for today's hearing date.
Ms. Fell, if you'll follow along in your binder, do you have any objection to Exhibit 1 being considered as evidence in your case?
No, Your Honor.
Exhibit 1 will be admitted without objection.
Exhibit 2 is the license history certification for the petitioner.
Ms. Fell, do you have any objection to Exhibit 2 being considered as evidence in your case?
No, Your Honor.
Exhibit 2 will be admitted without objection.
Exhibit 3 is the petition for early termination of probation and the attachments in support.
Ms. Fell, do you have any objection to Exhibit 3 being considered as evidence in your case?
No, Your Honor.
Exhibit 3 will be admitted without objection.
Exhibit 4 is the stipulated settlement and disciplinary order, along with the statement of issues.
Ms. Fell, do you have any objection to Exhibit 4 being considered as evidence in your case?
No, Your Honor.
Exhibit 4 will be admitted without objection.
Exhibit 5 and 6, we are requesting to be introduced pursuant to a protective order. Exhibit 5 is the counseling and therapy quarterly reports.
Ms. Fell, do you have any objection to Exhibit 5 being considered as evidence in this case pursuant to the protective order identified by Ms. Crawford?
No, Your Honor.
Exhibit 5 will be admitted pursuant to that protective order. I reviewed Exhibit 5 and find good cause to sign the protective order with regard to that exhibit.
And Exhibit 6 contains the psychological evaluation.
Ms. Bell, any objection to Exhibit 6 being considered as evidence in this case pursuant to the protective order identified by Ms. Crawford?
No, Your Honor.
I've reviewed Exhibit 6 and find good cause to sign the protective order with regard to it. It will be admitted pursuant to that protective order.
I have no further evidence to present at this time.
Would you like to give a brief summary to orient the board?
Yes, Your Honor.
Thank you.
The board issued the petitioner an associate marriage and family therapist registration on July 6, 2017. On March 20th of 2019, the board issued a licensed marriage and family therapist license to the petitioner that will expire on March 31st of 2021. A statement of issues was filed on February 27th of 2017, and a stipulated settlement was entered into effective July 7th of 2017, placing the petitioner on 5 years of probation. The statement of issues alleged that the petitioner was convicted of driving under the influence on 3 occasions in 2005, 2007, and 2012. Her blood alcohol levels were 0.08, 0.14, and 0.11 respectively. Pursuant to the stipulated settlement, the registration was issued, placed on stayed revocation with 5 years probation, and while on probation, the petitioner was to undergo a psychological evaluation, attend weekly psychotherapy, attend rehabilitation and dependency support programs, abstain from substances and drug test, and attend remedial education and pay costs. The petitioner is compliant in all aspects of her probation. As the burden is on petitioner, I have no further statements, but would reserve the right to question the petitioner.
All right, thank you, Ms. Crawford. Ms. Fell, would you like to testify on your behalf?
Yes, please.
You may do so.
Okay. I wrote some notes because I wasn't prepared for a statement. I did do a statement letter, so. The last 2.5 years have been pretty challenging for me with the probation. It's taken a lot mentally, financially, spiritually. Excuse me. I have been doing the same terms the entire time. I haven't asked for them to be lowered, just to prove to the court and the board members that I'm very serious about my license. I've been with good standing this entire time. I've continued with my sobriety, which is very important to me. I know that drinking will never be something that I can do in my life because I have a problem with it. So my sobriety is really important. No one close to me drinks, so I'm never really in any situation where I'm tempted. My boyfriend doesn't drink, my parents don't drink, so I find that that's been very helpful. I do have quite a bit of sobriety time, so even if I was around people that were drinking, I feel that it would not influence me in any way just because my sobriety is so important. My therapy with my therapist has been wonderful and has really helped me and changed me for the better. I actually think this whole situation has changed me for the better, even though it's been really hard. I've learned great coping skills to do when I need them, when I go through difficult times in life, of course. I've grown personally I, too, like our first petitioner, have gotten into being really healthy, eating well, exercising. I lost quite a bit of weight. I'm really a preacher of self-love and self-care, and I try and practice what I preach to my clients. This whole situation and going through all of this has helped me immensely working with people with drug and alcohol problems in my private practice and the counseling center that I work at. It really allows me to connect with them better and have that compassion, because I too have gone through it and still am. And it helps me to be a better therapist, because I think, you know, there are therapists that haven't gone through a lot in their life and they can be really great, but I think the people that have gone through a lot really bring a lot to the table. My clients' needs are very important to me, and being legally and ethically aware in my practice is definitely something that is very important. I don't ever want to put myself in a situation where I'm compromised again, where I could lose my license. And I will never take my job or my license for granted. I think that's all I have for now. Thank you.
All right, thank you. Do you have any additional documents or other witnesses to call?
No, Your Honor.
All right, Ms. Crawford, do you have any cross-examination?
Yes, Your Honor. Ms. Fell, do you consider yourself to be a recovering alcoholic?
Yes. Yes.
Thank you. And have you determined through therapy or otherwise what led to your problems with alcohol that led to the 3 DUIs?
Yes, I used alcohol to cope with. The first 2 was a breakup, unfortunately, with the same person. And the third was because the accidental death of a friend. So gaining healthy coping skills has been, very important.
And those incidents led to the DUIs, but generally, were you using alcohol to cope with stressful situations in your life?
Yes.
In your psychological evaluation, which is in Exhibit 6, the evaluator on page 5 of his evaluation.
Can you repeat your question?
I'm sorry, can we talk about this? I thought that would be under protective order to talk about the psych evaluation or her therapy.
The psychological evaluation is under protective order, but I need to wait for the question that's asked before I can rule on whether answering it would violate that protective order.
Thank you.
So, Ms. Crawford, at this point, you're identifying a part of the protective order, and my guess is that you were going to ask the petitioner to read it silently and not read it into the record, correct?
Your Honor, I was going to ask a question about a comment the evaluator made, and I do apologize. I had off-record discussions with the petitioner where she indicated she didn't have a problem going into the evaluation, even with parties present, but that wasn't on the record. So let me stop there.
Okay.
I was going to ask a specific question about the evaluator's opinion.
But at this point, you've decided not to ask that question.
I would like to ask it, but perhaps we need to do that in a cleared room.
Okay. Is that what you'd like to do? Are you making a motion to clear the room to
Yes,
ask that
please.
question? Okay. Any objection to that, Ms. Fell?
No,
All
Your
right.
Honor.
So that that motion will be granted. I'll have the room clear of anyone who's not on the board or our court reporter. We're back on recording or not?
We good? You're ready? You're ready. Okay, we're good.
Terrific.
Back on.
Are you ready, Mark? I'm all ready. Okay, we are back on the record out of the pseudo-closed session. Ms. Crawford, do you have any additional questions for the witness?
I do, Your Honor. As part of your hearing, you've testified and you've submitted some documents, and those are things that the board considers in determining whether your probation should be terminated. But one of the other things they consider is your demeanor. And your demeanor certainly speaks, any individual's demeanor speaks volumes as well. What we've observed of your demeanor is that you, from the beginning when you were giving your statement, up until various times throughout the hearing, you have been emotional and you have sometimes had to fight back your tears. And I want to know from you what that demeanor conveys to the board, because one potential is that the anxiety and the stress that led to the drinking and the problems are still very much prevalent, maybe not yet controlled, maybe a cause for concern, because in your profession, demeanor is so critical to having being able to have a good session with a client who's having the problems. So can you explain how your demeanor should be considered by the board?
I think being emotional is just because I feel heard by you guys and I'm able to be here. Of course, I don't cry in my sessions with my clients. However, I do feel deeply, and I have a lot of empathy, but really today it's just more that I'm able to be here and be heard by all of you, and that you can see what I've gone through, and not that I need alcohol or drugs to deal with this. That this is just because this is a stressful situation, and it's not something that I've been through before. So just, all of the last, since my last DUI in 2000, when was that? 2011, to going to school, for them telling me in school, you might not get licensed, to being able to get my associate number and licensed and do everything that you guys have asked, is just kind of showing.
Thank you.
Yeah.
Any additional questions, Ms. Crawford? No. Ms. Vell, do you have any additional testimony you'd like to offer?
No, Your Honor.
Do you have any additional witnesses or documents to present?
No, Your Honor.
All right. If that's the case, then in a moment, I'm going to ask whether the matter is submitted. And by that, I mean, do you feel satisfied you've had the opportunity to present all evidence and make all argument on your behalf? Ms. Crawford, is the matter submitted?
Yes, Your Honor.
Ms. Vell, is the matter submitted?
Yes, Your Honor.
Then the matter is submitted, the case is closed, and we are off the record.
Thank you.
We're off the record, yes.
And we don't need this on the record, no. So we are going to go into closed session. The board will get their lunch, bring it back, and as soon as we're all assembled, we will go into closed session. We will go back into open session again at 1 o'clock or thereabouts. All right? Does that work for everybody? Great, thanks.
No, sir.
All right, we are on the record in the petition for reinstatement or modification of penalty for the removal of supervision and therapy provisions for Cassandra Pacheco. It is OAH case number 2019-100907 and agency case number 2002-016-002-022. My name is Sean Gavin. I'm the administrative law judge assigned to hear this case. Can I invite the board members to identify themselves, starting with the farthest on my right?
Christina Wong, LCSW member.
Crystal Anthony, LCSW member.
Leah Brew, LPCC member.
Jonathan Maddox, MFT member.
Betty Conley, LEP member.
Max Disposti, public member.
Deborah Brown, public member.
All right, thank you. We've previously determined that these members constitute a quorum. Ms. Pacheco, as I said at the outset, after I take appearances of the parties, I'll have Ms. Crawford present your petition packet to the board and then present a brief overview of your case. At that point, you'll have the opportunity to object to any documents. We'll mark them and rule on those objections and then admit those into evidence. And then we'll go to your presentation of evidence. You'll have the opportunity to testify yourself or present documents or call other witnesses. Any questions about any of that?
No, sir.
All right, Ms. Crawford. Oh, can I take appearances of the parties starting with counsel?
Anahita Crawford, Deputy Attorney General, appearing on behalf of the Attorney General's Office pursuant to Government Code Section 11522.
Thank you. And Ms. Pacheco, the record should reflect that you were here today without the assistance of counsel. Is that correct?
Yes.
All right, thank you. Ms. Crawford.
Yes, Your Honor. I'd like to provide you with a packet. I have provided a copy of this packet to the petitioner as well. And at this time, I would seek to introduce the contents of the packet. They consist of 6 exhibits. Exhibit 1 is the notice of hearing of today's hearing date.
Ms. Pacheco, you have the exhibits in a binder in front of you if you'll follow along. Do you have any objection to the consideration of Exhibit 1 as evidence in this case?
No.
Exhibit 1 is admitted without objection.
Exhibit 2 is the license history certification for the petitioner's license.
Ms. Pacheco, any objection to Exhibit 2 being considered as evidence in this case?
No.
Exhibit 2 is admitted without objection.
Exhibit 3 is the petition for modification of penalty and attachments in support.
Ms. Pacheco, any objection to Exhibit 3 being considered as evidence in this case?
No.
Exhibit 3 is admitted without objection.
Exhibit 4 is the stipulated settlement and disciplinary order, along with the amended accusation and statement of issues.
Ms. Pacheco, any objection to Exhibit 4 being considered as evidence in this case?
No.
Exhibit 4 will be admitted without objection.
Exhibits 5 and 6 are requested to be admitted under a protective order. 5 is the counseling and therapy letters from petitioner's counselor.
Ms. Pacheco, any objection to Exhibit 5 being considered as evidence in this case, subject to the protective order identified by Ms. Crawford?
No.
Exhibit 5 will be admitted pursuant to that protective order. I've reviewed it and find good cause to sign the protective order for it.
And Exhibit 6 is the psychological evaluation of petitioner.
Ms. Pacheco, any objection to Exhibit 6 being considered as evidence in this case, subject to the protective order identified by Ms. Crawford?
No.
I reviewed Exhibit 6 and find good cause to sign the protective order for it. It'll be admitted subject to that protective order. Would you like to present an overview of the case for the board, Ms. Crawford?
Yes, Your Honor. The board issued the petitioner an associate clinical social worker registration from July 23rd to August 1st of 23rd of 2013 to August 1st of 2017, when it expired. The board then issued a licensed clinical social worker license on November 16th of 2017, which will expire May 31st, 2021. The license is on probation for 5 years, terminating October 17th, 2022. The probation is based on an amended accusation filed April 4th of 2017 and a stipulated settlement which became effective November 16th of 2017. The accusation alleged that in 2016, the petitioner was convicted of welfare fraud, a felony. The accusation further alleged a basis for discipline for unprofessional conduct and committing a fraudulent or dishonest act. The basis was that in 2013, while receiving government assistance from the Department of Social Services, the petitioner failed to disclose her employment or her income on an eligibility form and continued to do so for nearly a year before her misconduct was discovered. The probation terms required psychological evaluation, psychotherapy, law and ethics course, supervised practice, cost recovery, and standard terms. Petitioner is seeking modification of her probation and requesting the board remove the probation conditions that require her to have supervised practice and therapeutic counseling. She has been compliant in all other aspects of her probation. As the burden is on the petitioner, I have no further statements, but would reserve the right to question the petitioner.
Thank you, Ms. Crawford. Ms. Pacheco, would you like to testify on your own behalf?
I just wrote a brief statement.
Well, before you do that, I just want to verify that you want to, in
Oh.
case I'll have to swear you in.
Yes.
Can you stand and raise your right hand? Do you solemnly swear or affirm under the penalty of perjury that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you very much. All right, now, go ahead.
Okay, so I'm going to try to keep this really short and sweet to avoid repeating information that's already in the petition. Yes. Do you want me to start over? Okay. I'm going to try and keep this short and sweet to try and avoid repeating information that is already in my petition. I am requesting to remove supervision and therapy requirements from my probationary requirements to be able to dedicate more time to my client's family and self-care, such as camping and painting. I have been compliant with therapy and supervision, and my providers are in support, as well as indication of safe practice on my psych evaluation. Even before being placed on probation, I began to heal from my experiences by reauthoring my narrative as a learning experience that can help me in my practice, as I had always and continue to work with justice system involved clients, so my experiences helped me to develop a deeper empathy.
Is there anything else you wanted to add at this point?
No.
Okay. Do you have any additional documents that you wanted to offer on your own behalf?
I do.
Okay. Can you do that now?
Yes.
Okay. They'll be distributed presently.
Do you want to do the other one now too, or later? Okay. Okay.
Thank you. You're welcome. Ms. Pacheco, is it just the one document that you would like to introduce?
There is a second document that's going to be verbally reported.
Okay. Well, maybe I should be more clear about document. I mean, a physical document that you'd like introduced as an exhibit.
It's not going in right. No, that's the only one.
Okay, we'll mark this as Exhibit A. It's a 2-page order of dismissal in Superior Court case number SS160673A is an alpha. Looks
Your
like
Honor,
it's-
can I ask a question?
Yeah, go ahead.
For the edification of the board and those of us that are not legal experts, could someone explain what this document is? Because I don't quite understand what it is.
Well, it's the petitioner's document, and so I'll have, if you'd like to ask her a question about it, once the time to question her comes, I'll have her explain the significance of it. And it may be that in closed session, the board may have the opportunity to consult with its own counsel about the significance of it. Yep. Any other documents or testimony you'd like to offer at this point, Ms. Pacheco?
Yes, so I wanted to enter in the the quarterly statements from my supervisor while leaving out the actual client, like summaries. I think they're submitted backwards. No, they're not, are they? Which one? Okay, thank you. So what it says is Cassie has maintained all of her supervision sessions. She presents with a good understanding of clinical assessment and the need for continued assessment.
Let me stop you for just a moment, just so the board understands as you're reading it. Can you tell us what you're reading from? Because
Yes.
it's my understanding you're not going to submit this as a documentary exhibit, is that right?
Yes. So when I had submitted my packet, the letters that are attached to the quarterly reports from my clinical supervisor were not in there. And so she's having me read just the part that pertains to my practice.
Okay, so this was an attachment to a quarterly report from your clinical supervisor?
Yes, on January 4th of 2019.
Okay. Before you continue, Ms. Crawford, do you have any objection to Ms. Pacheco reading from this document?
I don't have an I'm sorry. She did show me a copy of the document. I don't have an objection to the portion that she's going to read into the record.
Okay, all right. And again, I don't mean to interrupt. I just want to make sure the board understands what they're being read to from.
Of course.
All right.
Do you want me to just start over?
Yes, please.
Okay. Cassie has maintained all of her supervision sessions. She presents with a good understanding of clinical assessment and the need for continual assessment. She is able to establish rapport with her clients in any environment. She is very comfortable with her clients and wants to advocate for them whenever possible. One weakness I have seen in Cassie is how she verbalizes her desire for the cases and the clients to move faster than they are.
Can you go a little bit slower?
Sorry. It is a combination of being impatient and a desire to accomplish a lot in a short time. And then I think. And do you want me to read the other summary too from April of 2019?
I think you need to indicate the name.
Oh. This got very confusing. And so, sincerely, Gabriella Dodson, LCSW, Family Service Agency of Santa Barbara County. And then, where did that one go? And then the second one is dated April 2nd of 2019. And it says, Cassie is doing well in her placement. She has a baby boy in late January, ! She has been working with the team and communicating in a timely manner. She has a casual way of building rapport with her clients and the staff. I look forward to continuing to work with her. Sincerely, Gabriella Dodson, LCSW, Family Service Agency of Santa Barbara County. And I think. And that's the end.
And Ms. Dodson is your clinical supervisor?
Yes.
And signed the quarterly reports that are attached in the petition packet?
They were not attached. I noticed this morning that they were missing.
The quarterly reports or those attachments from which you just read?
Both.
Okay. All right. All right. Any other testimony or documents that you'd like to offer at this point?
No.
Ms. Crawford, any cross-examination?
Yes. In your petition, as part of an explanation as to what brought you before this board, your statement was that you had a conviction for fraud in obtaining aid, that you faxed proof of your employment to the Department of Social Services, but they apparently didn't receive it. Is that your representation of why the accusation was filed in this case? Because of that conviction?
Yes, the supervisory requirements were a result of that conviction.
Okay. And it's also your representation that you had faxed in your proof of employment, but that Social Services apparently did not indicate they ever received it.
Since the case resulted in a conviction, I would rather not discuss the details and just focus on, I made the decision to, accept the plea bargain and face the charges and move forward with my license. And so in terms of the purpose of this, I was convicted of the crime, so I would be considered guilty.
Okay, I want to ask about the basis, which if you were able to be present in the hearing room for previous petitioners, the basis of the accusation is always an issue that the board needs to consider in determining rehabilitation. Otherwise, there is not really a way to consider whether your petition can be granted or denied. So I'm going to continue on with my questions for those reasons. And the question I have is that while your statement to the board said that you had faxed in some paperwork indicating that you were in fact employed, that's inconsistent with the information from the investigation report, which stated that you had several opportunities to express that you were employed and gaining income for 5 months, if not up to a year, but failed to do that. That's an inconsistency that is in the record. It's inconsistent with your statement in your petition, and I'm wondering if you can reconcile those two statements.
Yes, so what they're referring to is my case had transferred from LA County to Monterey County, and it took about 5 months for them to efficiently close it out and reopen it. And so in that meantime, there was a, I think it's the SAR 7, the semi-annual reporting. And in that one, based on my communications with the supervisor, I believe his name might have been Mark. I can't remember, but it should be in there. I was kind of under the impression to fill it out as if I was still applying because it hadn't transferred over from the previous county. And that was, I guess, inaccurate and a mistake on my part.
It was inaccurate how you filled out the form, is what you're saying?
So what was inaccurate was my understanding of the instructions that I had been given
Okay.
through my verbal conversations with him. So on that form, I did put that I was not working because I was under the understanding that I was supposed to fill it out as if when I had first applied because it hadn't transferred. But again, that was an error. So I was supposed to have put the income on that one as well.
Okay. And another part of that investigation revealed that you did not, for up to 1 year, report income or your employment until, in fact, it was discovered by the Department of Social Services, which would seem to indicate that you had no intention of disclosing your income. Is that accurate?
No. So I was under the impression that they had received the fax, and then after the case, it took about 5 or 6 months to transfer over. I was under the impression it had closed and I was receiving transitional benefits because you're supposed to get food stamps for 6 months after your case closes. And then during that time, they were also giving me $300 a month in cash aid, and they were keeping my $350 in child support. And so I just believed that it was kind of part of, oh, since she's still getting the food stamps and it's an even amount of money, I didn't even register to think that it wasn't closed. And I actually, when they sent me the letter to renew, I called and I questioned them, and I had them close it after about, I believe it was 9 months, which would have really only been like 2 or 3 months over the expected limit.
That incident caused the accusation to be filed, and part of the concern of the board was if there are errors on your part, or intentional or otherwise, in filling out forms in a manner that could be viewed to your benefit, then it could give the board the impression that you are dishonest in disclosing important matters if it would be to your detriment. What can you say to reassure the board that you have been and will continue to be honest and accurate in your representations to them?
So since this incident in my personal life, what I've done is I basically have followed the standard practice of social work. If it's not documented, it didn't happen. So I be sure to document any important phone calls, or if there's anything faxed or sent, I make sure to keep the fax cover sheet, as well as anytime I'm given information on how to fill out a form, I make sure to keep a copy of the instructions. For example, I did end up back receiving aid in, I think, 2017. And I actually saved the voicemail in which the worker had told me to check a box that my mom had moved out, so that way they wouldn't have us under the same household because we had separate finances. And so even though that was not the extremely correct way to fill out the form, that's how she was advising me to do it. So I made sure to save that voicemail to prevent any future misclarifications or another incident like this happening.
I don't have any other questions. Thank you.
All right, at this point, then let's open it up to questions from the board, starting with Ms. Wong.
Hi, good afternoon, and thanks for being so patient.
Thank you.
So, maybe just make it very simple and straightforward. So based on your testimony, are you saying that the welfare fraud that you committed, it's not intentional?
While it was not intentional, I understood where they were coming from, and I did not feel like it was enough of a case for me to fight in court. So it was like I was paid. But again, as I explained, because they were keeping the $300 and giving me the $300, and because of the period of time for transitional, it was unintentional, and I did pay all of it back. And actually, my last month of getting aid in a different county, I was overpaid again because they did not communicate the, I guess like one worker was out and she didn't get the information from the other worker. And the minute I was overpaid, I immediately made sure to call them and document again that I was reporting that I was overpaid. And luckily, they were able to close out the case, and that 1 month of overpayment, I was able to pay back. So I think there's oftentimes errors in the system, and I think that unfortunately, I may be more aware of them than the average consumer because of my education and my background. And I think I have some concerns about the lack of accountability for social service errors. And I think that when they had initially requested the overpayment, I had objected to it and tried to appeal it, feeling that felt like it wasn't fair. And I think that part of the conviction was a result of, instead of just agreeing to pay it back, trying to fight it. Again, I felt it was unfair that they were keeping my child support, and having me pay back money. So I ended up actually having to pay back double because they kept the money that they kept from me. And so I think through fighting and trying to appeal all that and almost trying to advocate and make systematic change, I actually dug myself a hole. So while it was not intentional, it happened, and I did acknowledge and admit I was overpaid. I did pay it back, and I've been able to again learn from it and really make sure to document everything. And even just sitting in the courtroom, it helps me to understand where my clients are coming from now, because I've been there and all the uncertainty, and it's not a fun experience. And it really, I think overall, some good came of it. I got to spend more time with my family. I think it's made me a stronger person. And I was convicted. So again, it did happen.
So help me understand. So your amount that the amount of dollars is $8,086, right? Is that amount, $8,000 something dollars?
I think it ended up being a little bit less than that. I think it ended up being more like 5,000 because
And that's how much money you have to pay back, or was it that money?
So it was they had me pay back the total amount, which included the 6 months of transitional food stamps that I should have gotten anyway, and they had me pay back $300 a month of cash aid, while keeping my $300 of child support. So, does that make sense?
Yeah, it does.
So it really should have only been like 3 months of food stamps, and in my opinion, I shouldn't have had to pay back if I paid it back, they should have paid me back the child support, because it was they keep the child support for giving you the cash aid. But I lost that hearing based on a one sentence that basically just said, if it's an overpayment, we don't pay you back your child support. So I ended up just paying it all back.
So thanks for shedding some light about that dollar amount and your view of what happened. So my other question is that now the accuracy is really important. Mm-hmm. So and you work in what kind of agency that you work for, employment wise?
So I work for a family service agency, but I'm posted in the public defender's office.
Okay, so you don't do you do any billing for counseling service and stuff?
No.
Okay. All right. So now, so sooner or later, you're going to get your license, and, so if there's any chance that you have to do any of the billing service, what are you going to do in order to make sure the accuracy?
So I do think it is important to note that the context was not work related, and while I totally understand that there's a crossover, I worked and I did bill Medi-Cal for about 3.5 years, and my supervisor never had any complaints. I always got everything done on time, and obviously I was an ACSW, so I was under supervision, and there were never any concerns about my accuracy of documents or any type of billing issues. I know that we went through at least 2 audits from when I worked there, and there was never any issues that came back. One of them might have been, I think probably they audited stuff before I worked there. But the second one, again, if there were any discrepancies in my billing, it would have came up in the audits.
Okay. Thank you very much.
Thank you.
Hi.
Hi.
I want to thank you for being here. And I want to, oftentimes, this is only my second day here. So oftentimes, there's people that have come up here, and I recognize the struggle of what has happened and the system in and of itself. And I really want to acknowledge your resiliency through that. And as you were talking and as you were speaking, and I heard that you said you work with justice, system impacted youth, and your struggle and the challenges that you've overcome, there's a connection that you're going to have with those youth that nobody else is going to have unless they've been through it too. And so, I'm going to tell you, I'm going to say something to you. It's it's from one of my favorite authors, and he's a criminal justice reform person. You might even know him, Brian Stevenson. but there is strength and power even in understanding brokenness, because embracing our brokenness creates a need and desire for mercy, and perhaps a corresponding need to show mercy. When you experience mercy, you learn things that are hard to learn otherwise. You see things you can't otherwise see. You hear things you can't otherwise hear, and you begin to recognize the humanity that resides in each of us. And you are an example of for your clients of what mercy is, and I feel like you seem to understand and have learned from what system can do to you, and I hope it's built that empathy. So I want to hear a little bit about what you have learned and how that has changed you in a way that is going to be a positive thing for consumers.
So I think the biggest part is to actually really feel not just an empathy, but an understanding of, when they're sitting in the courtroom and, maybe they're anxious about what's going to happen, and sometimes they'll like, oh, should I apply for a job, or, should I wait because I really don't know what's going to happen? And I'm able to kind of help them be in the moment and help them be like, we don't know what's going to happen, but let's cope with it. Let's, take some deep breathing, maybe let's go take a break outside the courtroom and come back. And let's just do what we can to better our situation in the moment. And, we don't know what's going to happen 6 months down the road. And I think that's kind of the scariest part of being a part of the system, is there is so much unknown, and being able to kind of help them navigate that and really focus on what they can control and not focusing on the things that are out of their control.
And one thing I want to thank you for is acknowledging, just like taking ownership of what occurred and of the accountability of just saying, like, just how you've come and presented yourself. I want to thank you for that. Like, I want you to know that I know that it takes strength to sit in that seat, and so I'm really grateful for that, for you to do that for us. And my other thing I want to ask you is, what has your healing process been like through your rehabilitation and this process?
So I have been going to therapy as a part of the requirements. I think initially it was great because it kind of gave me that little push that I needed, because just with work, and then I have 4 young kids at home, and it's just finding that time. It's very easy if you're not required to kind of push your own needs back, and this kind of forced me to go into therapy and address some of my childhood stuff that I've just kind of pushed back because I've been focused more on meeting basic needs. So it's been a little bit over a year, and I mean, at this point, my therapist and we both kind of feel like I'm at a point where, I'm not perfect, I'm human, I make mistakes, but it would probably be more beneficial to do, more focusing on my family. So for example, if I were to be not required to do therapy here, I could focus on maybe like family therapy with my kids, or focusing some of their own issues, as opposed to having to take that time away from them and put it on me.
And what are some things that you do for coping?
So my 2 are kind of camping, and my therapist actually got me started in painting, although I did recently lose my paint. I try to hide them from the kids, and they're missing now. I just hid them too well. So, but I've done a few drawings or paintings, I guess, and I forgot how much that kind of, even though I'm not good at it, it really kind of helps me to relax. And I don't get very much time to myself because there are a lot in my family, but just even taking that time to just kind of spend an extra 5 or 10 minutes in the shower when you're by yourself, and just kind of deep, breathing, and just kind of take that moment to just be like, oh, today's a new day. Let's just get through our day.
And how would modifying probation help you?
So when I have my therapy appointments, I have to go pick up my kids from school, literally drive by my house, drop them off. There's an adult inside the house, and then go off to my appointment. And they'll ask me, maybe twice a week, oh, Mommy, do you have an appointment today? I don't want you to go to an appointment. Sorry, I talk really fast, I know. Sorry. So they'll ask me, oh, do you have an appointment today? If they have like a scouting event, they'll have to miss that. And so in terms of my own self-care, I think not being mandated to go every week and being able to go more at my own convenience and not having there be a negative consequence if I, were to have to go would, obviously my family is important to me and taking care of them is important too, as well as myself. And then in terms of supervision, so meeting once a week for an hour. Sometimes I have to drive an hour each way to meet with my supervisor, and sometimes we meet in my office. And so that's time that's being taken away from the clients. And there's times where maybe a client has a court date and I cannot be there for them because I have to go to my scheduled supervision. Because obviously the courts aren't going to schedule clients' cases around my supervision, and my supervisor doesn't have the flexibility to schedule other than our kind of set block. And so not being required to have supervision would allow me to dedicate more of, the 40-hour a week to client care.
Are you an ASW or LCSW? LCSW, okay. ASW. But you're an LCSW. Okay. I'm
Yes.
just making sure. Sorry. Thank you.
Thank you.
Thank you for coming. So can we just back up to the beginning somewhat? Because I am unclear on what actually transpired, just your side of the story. What I'm reading in the documents is that, what I'm reading in the documents is that you were charged with basically not sending in documentation saying that you were working. And so they fined you and just ran you through the legal process for that. But I would like to clarify your side of the story because I'm unclear. So did I hear you say that you faxed it over and no one received it? Is that your testimony? I was just unclear.
Okay, I'm going to try to keep it brief.
You don't have to keep it brief because I'd like to understand.
Okay.
So if it requires you,
So
if it requires you to sort of expound on what you've already shared, please do that.
So I had an open case in LA County and I moved to Monterey County. And so I did an inter-county transfer because I moved maybe maybe like a month and a half before I had my job. So LA County is one of the few counties that doesn't have like the inter-county connective system of social services. And so it took them about 5 months to get the case from LA to Monterey County. And so throughout that time, there was back and forth communications about, how to do it, multiple supervisors, multiple people involved in the case. So when I got my job offer, I faxed it over, and maybe a month or two after, the SAR-7, which is a semi-annual report, came in the mail. Now, my case still had not been open in Monterey County. And so I was consulting with a supervisor who basically, from the way I understood it, he was telling me, fill out the SAR-7 as when you initially applied. Because when it's an inter-county transfer, they are not supposed to update any information until the certification period. So I, at that point, did not know that they had not received my fax. And so I went ahead and I, filled out the SAR-7 inaccurately based on what I had believed were the instructions from the person I was consulting with. Mm-hmm. So after that point, I think it took another month or so before the case got opened, and the back benefits from when I wasn't working came, and then once your case gets closed, you get 6 months of transitional food stamps. So I kept getting my food stamps, and it didn't register anything to me because, again, that individual had never informed me that he never received my fax. And again, that's my error for not keeping track and documenting. I didn't keep the cover sheet. Sure. I didn't document every single phone call. And so when I was looking through the case file and looking at the case, they actually had tried to open it about a year and a half before, And then they closed it, saying, you know what, no, this isn't. And then they reopened it.
Okay.
And so I appealed their decision because I did not feel that I should have to pay back all 9 months. That should only be 3 months. And that I should not have to pay for any of the cash because I was not profiting or making money because they were keeping my child support. So I really was only in my opinion, overpaid for 3 months of food stamps. So I went in front of a hearing. I lost the hearing. So, I mean, the legal system is the legal system. If I lost, I'm obligated to pay it all back. And so I did. And by that point, when it went to the criminal case, so much time had gone by. And again, I'm kind of familiar with the system. And I was able to look, and it's not only a case of he said, she said, but it's a case of he said, she said, but she said is a large agency. And I do take ownership that I did fill out that one form inaccurately. And perhaps if I had done it correctly, it wouldn't, it would have triggered something totally different. And so I just went ahead and, took the plea deal where it was 1 year and then it was reduced. And after 2 years, it would be expunged or removed from my record, which is what that document that you were asking about earlier.
So if I'm understanding correctly, you were receiving aid from LA County first, and
Yes.
then went to Monterey County. You had to fill out a form, which was a part of the process, and LA County was transferring your case to Monterey County. Is that correct?
Yeah, so the form needed to be filled out. It was like the Monterey County form, but because the case was still being transferred, it was kind of open in both counties.
Okay.
And so basically, from what I understood, if I had reported my income on that form, they would have stopped trying to transfer it, and all those back benefits from the months that I wasn't working would have disappeared. And so that's where, again, I was under the impression that I was advised by the supervisor I was working with to fill it out like that.
I understand.
And so,
I understand the point. Thank you for the clarification. So were you actually working at the time you filled out the form and incorrectly filled it out?
yes.
Okay. So can you help the board understand, because I'm assuming the form was clear. I'm wondering, could you help us understand why you filled it out or how you were able to fill it out incorrectly?
Because once that form is filled out, again, there was about 5 months where I wasn't working, where I was not getting any benefits. And all those back benefits, if I had reported on that form that I was working,
Right.
because it hadn't transferred over, it would have just closed out and it would have disappeared.
Okay, thank you. So the Deputy Attorney General mentioned that even after you completed the form, there was a 5-month period or so where you were able to bring clarification that you were actually working. Is that accurate?
So that's not a simple yes or no. It was about maybe 9 months, but again, the first 6 months you get transitional food stamps, and so I was unaware that they did not know, and then it took me a while, and then I realized, hey, it's been about 9 months, and I called them to report that hey, I'm still getting benefits, what's going on? So I would say there was about a 3-month period that just, when you're busy and you're working, I'm not keeping track of each month. So it was not an intentional lapse of, does that make sense? Like a
It
lapse
sounds
of reporting?
Sounds like your reporting, it was an oversight
Yes.
on your part.
And then once I became aware that I was still getting them and it kind of registered like, hey, this has been a while. That was like the first time that I had gotten aid while working. And again, this time when I started my job, I picked up on it immediately. I was like, hey, it's been 1 day and you paid me. Let's call, let's see who we talked to. So I was able to learn from that and just always to cover my bases and
Okay.
always just verify everything and not just assume that things are received.
Sure. So if I'm hearing you right, and I'm just doing this just so I am clear and so I can make a decision based on clarity, you were receiving aid in one county, moved to another, maybe based on sort of feedback from a supervisor, incorrectly filled out a form, turned it in, was unaware that you had done anything fraudulent, and did not recognize that you needed to sort of address the inaccuracy of the form because you were still receiving aid until a little further down the line, which may have been 6 to 9 months, at which time you did inform them that you were working and you should not be receiving aid? I mean, would that be an accurate reflection?
Yeah, I got a renewal notice, which they usually send out like a month or two before it's due, and that kind of triggered me to realize, hey, it's been, a little bit more than 6 months. I think where, again, my kind of struggle is I do know more about the system than the average person, or the average, person involved in social services. And so to me, knowing that I was supposed to be getting that 6 months, it didn't even trigger to me that anything would have changed. Whereas if I maybe hadn't been aware of that rule, I may have been like, hey, why am I still getting money and called? So almost in this case, my education was my downfall and not my benefit.
Okay. All right, thank you for now. Thank you.
Thank you. Thank you for coming in. As you've heard, you've been here all day, and you know that our responsibility, the whole reason that we put people on conditions or probation is to ensure that they're safe to practice and that consumers are protected. So when we get a case like yours, we clearly are looking at the facts as we know them. So that's what we're looking at today, sitting here 2 years later, essentially 2.5 years later, after you went into the stipulated settlement. So during that 2.5 years that you've had supervised practice and therapy and all of this kind of stuff, have you grown from where you were 2.5 years ago to where you are now?
I would hope so. Again, I would like to think that even being able to, on my own before, going to therapy, really being able to deal with all that stress by rewriting my narrative and finding the good in the situation, I think that that's probably one of the first times. Like, there was a lot of other things going on at that time for me. I was getting a divorce as well from an unhealthy relationship. And so I think from then I've been able to move forward, and I was able to refocus on my kids. I was able to volunteer for about a year before getting employment to give back to the community. And I think I've been able just to really grow in terms of protecting myself, in terms of, really making sure that I'm covering all my bases, that I'm re-clarifying anything, and also just to be able to find the good in other situations. It kind of forced me. I mean, I either had two options, like go down a negative spiral or kind of upgrow from it. And I think since then, it's kind of been mostly uphill. I mean, there's always little dips and, nothing is ever perfect, but being able to just reframe negative things into positive things and to help others also and be able to kind of reauthor their narratives. It gave me the opportunity to work on some childhood trauma, which I probably wouldn't have had if I wasn't in this situation. I think it's helped me be a stronger advocate for people. I think that there's a lot of my clients have similar kind of system struggles and navigating the system, and it helps me be a stronger practitioner in that sense. It helps me advocate for my children. I had to get IEPs for them, and because of my background and my knowledge and, going through all this, I'm able to just become, stronger and really know, hey, if I know that something is a need that needs to be met, I need to push for it, and I need to really do all my research and really just keep moving forward.
And what about the supervision?
Have I grown from it?
Has that been a
Or-
benefit? Are you gonna, how is that gonna change your practice going forward?
I think that while it's never harmful to have supervision, I think in this context with my clients and my caseload, I would better benefit from peer supervision with so there's a few other social workers in our office, and I think I would grow more with case consulting / supervision with my coworkers / colleagues who work in the same practice, because when you intersect, social work and the law, it's a unique field that not everyone is always aware of the differences and nuances. And so while my supervision has been helpful, if it were to be terminated, I would be able to spend that time case consulting with my coworkers and colleagues instead, which I think would be more helpful to the clients.
And that's a practice of the agency that's done?
We're working towards it. There's only one of us, and now there's two of us. Well, I'm the second of us, so there was a person, and then now I'm the second one, and so that's the hope. But when there's only two social workers for, one in a different public defender's office, we have, pretty high caseloads. And what's been kind of inhibiting that is I do have to block off time for supervision, which I already have that time blocked off. We could kind of work that into our case conferencing instead.
Thank you.
Thank you.
Not further questions from me, so thank you for being here.
Thank you.
I have a question about the handout, the
Yes.
handout that you gave.
Yes.
The record should reflect that's Exhibit A.
Exhibit A?
A.
A, okay. Exhibit A. It says that your petition was dismissed, right? The court granted the petition for dismissal?
Yeah, so not that the petition was dismissed, but that my petition to dismiss the charges. So basically an expungement. Sorry. Basically an expungement.
Okay, so what, the crime
Yes.
has been expunged?
Yes.
Okay, that's important. Thank you for that. And my last question is, you submitted for modifications. Why didn't you submit to just get them all removed? Just early termination?
So I think it was you, Miss Betty, who said it was about 2.5 years since I signed. However, the first year I did toll my probation. So it's only been about 1.5 years-ish. So I'm not able to. So this is the first step.
Okay.
So maybe I'll see you guys again.
Okay, so it's your inability to do it, not,
Yes.
okay. All right, thank you. I have no other questions.
Thank you.
Ms. Wong, you have another question?
Yeah, just follow up. So, when was your period that you told your probation? Do you remember?
I know that it was untold September of, wait, 18? I'll make it a, hold on, let me think for a second. 18, September. Yeah, so it was untold September 1st of 2018, so it would have been from November, whatever date, 16th or 17th of 2017 to, and that was mainly because my children, my 3 oldest, the 2 were not school aged, and so I was waiting until they were in school to kind of do anything. But then I had another baby, so that was kind of, there was no point in really waiting.
So you basically told for about 10 months altogether, or right around?
Yeah, it was about a year.
Okay, perfect. Thank you.
Thank you.
So, can I just make an actual comment? So that means that technically you've been on probation probably 1 year and 2 or 3 months? Would that be accurate? Is that?
Yeah,
Okay.
I've been practicing, for about 1 year and 3,
Thank you.
Prior to your testimony, you had read from the report of, I think it was Ms. Dodson, and I'd just like to ask the board, now that the board has a deeper understanding of the petitioner's testimony, do you folks feel like you need to rehear that? Because you're not going to get a copy of that as an exhibit to review. I'm seeing heads shaking no. Okay, good. Ms. Crawford, do you have any additional cross-examination? Ms. Pacheco, do you have any additional testimony you'd like to offer on your behalf?
Just I'd like to thank you all for your time, and hopefully I see you guys all in a year for the next step.
Do you have any additional witnesses to call?
No, sir.
All right. If that's the case, then in a moment, I'm going to ask whether the matter is submitted. And by that, I mean, do you feel satisfied you've had the opportunity to present all evidence and make all argument on your behalf? Ms. Crawford, is the matter submitted? Yes. Ms. Pacheco, is the matter submitted?
Yes, Your Honor.
All right, the matter is submitted. The case is closed, and we are off the record.
Thank you.
We're going to take a 10-minute break. Come back at